Lordship, may I permit to mention a matter? Lordship, second appeal for condemnation of delay application, Lordship.
May I be permitted to mention? One new motion.
Second appeal, criminal appeal.
No, Lordship, second appeal. There is a delay, Lordship.
My lord, my lord, may I be allowed to mention one matter? Actually,
Yes.
two matters, my lord. It is for extension of stay order. Mr. Pal would be handing over these slips, my lord. The extension period extends
Are
till
you
20.
mentioning upon notice?
No, my lord. We have intimated other side, my lord, because it is a stay
Mention upon
application, my lord.
notice. Please mention upon notice.
My lord, whom to? My lord, we have mentioned it, my lord. We have noticed it, my lord.
Please show me the notice.
Mr. Pal, please hand. My lords, my lord, may I? My lord,
Extensions should be upon notice to the other side, right?
my lord, it is after admission, my lord. Other side did not appear, my lord, till date.
No, but there for extension there should be there must be a direction for
My
service.
lord, tomorrow kindly keep it on the list. We'll hand over the affidavit of service of this extension what we have made. Mr. Pal, please hand over these two extensions. Tomorrow we will hand over, my lord, the two affidavit of service.
Yes. Next.
Motion.
New motion.
New motion. Yesterday I mentioned, my lord, not in the list, my lord, stay of warrant, my lord.
Not in the list. কি হলো আসলে কেন?
Stay of warrant.
হ্যাঁ? ইনক্লুড আনাতে হবে তো শুধু স্লিপ পাঠালে কাজ শেষ হয়ে যায় না।
May I be
কালকে
permitted to
সেটা
mention?
list এ থাকে ওটা।
May I be permitted to mention, Your
Yes.
Lordship? One new motion and one admission of appeal.
Lordship, may I permit to mention a matter? It's for contested application. I already served, Lordship.
Contested applications cannot be taken up in these
Lordship,
proceedings.
I already served, Lordship, but they are not appeared.
Give the number, let me see.
Great, Lordship.
Lordship, may I permitted to mention a matter? It's a hearing matter, criminal revision, Lordship. Stay was earlier granted, and there is a direction of upon the petitioner to serve the copy upon the respondents. We have already complied the
Give
direction.
the number, let's see.
Grateful, Lordship.
No more mentionings. Call the day's list, please.
I am for the applicant, my lord.
My lord, I am for the respondent, my lord. The judgment has been given, has been delivered by Honorable Justice Ajay Kumar Mukherjee, but that judgment suffers certain typographical error. Mr. Pal would be handing over that list what I have made. Mr. Pal, can you please deliver it?
Corrections will be done by the judge who has passed the judgment, who has delivered the judgment.
My lord, it is a typographical error, my lord. Hey, Mr. Pal, kindly please parcel it to judge.
Kumar Mukherjee, my lord. Judgment
Yes, you have to move before him, I'm sorry.
My
You can do it virtually. Yes.
my
Because,
as
corrections has to be done by the person who is, the judge who has passed the order, right?
my lords, my lords.
I cannot do that.
I concur what my lord says. My lord, thank you.
No order need be passed.
Item number 2. Item number 2 and 3.
Yes.
Lordship, yesterday, Lordship, both applicants, husband and wife, could not present the court. So, affirmation could not be done for the joint compromise petition. So kindly we let the matter be fixed on Friday, otherwise,
Lordship, I am appealing on behalf of the opposite party. Lordship,
Will you
mediation.
come back on Friday because the matter is settled.
yes.
It's
Can be
been settled.
disposed of.
You can be disposed.
Very good.
Great.
By consent of the parties, let the matter appear under the same heading on 20th December. Next. Have you served?
Yes, no, service from last occasion I had submitted the affidavit of service.
Case diary was called. Who is appearing for this case?
Issue price appearing for the
Mr. Neela Chakraborty and Mr. Sanjeev Das.
kindly
No one for the state today.
kindly pass it on.
I'll pass it over. Yes,
ওই দিক থেকে না, সামনে এসে বল।
item number 4. Mr. Neela Chakraborty is appearing.
Sparing on your list breaks in courtroom.
Passed over. Next. Passed over. Passed over.
Item number 7.
Yes, I'm for the petition. This is extension of interim order.
Served.
Okay, then. In this matter, I am for the opposite, 7 decades. Well, I am for the opposite party number 2, my lord. My lord, copy of the revision application has not been served upon us, my lord.
Twice I've served, first.
Only the application
Post
extension.
admission. Post admission, that's how.
Seven. Only I have only received these 2 applications, my lord, kindly see, I have the envelopes also. Only these 2.
Do you mind giving him
No,
another
no,
copy?
I will give.
My lord, kindly takes it
Let
up on
us
Friday,
wait.
it can be taken up on.
You
Yes,
please
yes,
give him
yes,
another copy.
Definitely.
My lord, kindly, if you also
Yes.
kindly takes it up on Friday, my lord, it can be heard and.
No,
complete.
contested applications cannot be further taken up.
Oh.
There is already a big
Well,
list
then,
of
my lord, kindly
contested
grant me liberty to
applications.
file a beginning application. my lord.
That was
Therefore,
there.
beginning-
Liberty,
That was there.
you have
Malad.
liberty, no further liberty. is
Malad.
necessary. For the state? Your opinion? I'll extend this for a limited period. Affidavit of service. Third learned counsels for the parties. Paragraph, interim order granted earlier is extended till 31st January 2025 or until further orders, comma, whichever is earlier. Paragraph, the matter be placed before the next available settlement.
Grateful. If you also kindly record one and to serve a copy upon us, my lord.
I'll not
Again,
record
I'll-
this because the affidavit of service is there on record. I'll request,
Sure.
please serve.
Absolutely.
Grateful.
Serve the learned counsel, it will be sufficient. Next.
Item number 8.
Passed over.
9.
So 9, was it, yesterday the matter was taken up, Lordship. There was a defect in filing of the application for extension of entry because there are 2 or 3 days time bar. So may I be given liberty to file afresh?
You
Extension
will
of,
withdraw this and file afresh, right?
only CRAN.
Only the CRAN, yes.
Yes.
On prayer of the petitioner, liberty is granted to withdraw the application being CRAN 1 of 2024 due to certain defects detected therein and file a fresh application on the same cause of action. Paragraph CRAN 1 of 2024 be dismissed as withdrawn.
Grateful. Same prayer in respect of next time.
10. In 10,
10.
10 is here.
Grateful. Lordship.
Next.
Item number 11.
My lord, I am for the appellant, my lord. My lord, appellant before your lordship is the defect to complaint, my lord. Seeking leave to
My
file
lord,
an appeal.
my lord, only one submissions before your lordship, I am for the accused. My lord, whether
You
leave
will
is,
have
re-
your.
my lord, whether leave,
chance.
my lord, on technical point, my lord, whether leave is required, lordship kindly see the 372 proviso.
This is against an acquittal judgment, right?
Acquittal.
Yes, yes.
378 force says so, that leave is required.
This has,
378
this has been
says-
proviso has been incorporated thereafter.
But
So my lord, he has the right to file appeal, my lord, without obtaining
since
the
it is
leave from the
magistrate
court.
level, leave is required.
That is not there.
My lord also sees 378 4. Similar situation, Malad has granted leave on the.
I have granted this. Let this be granted.
Malad, grateful.
My lord, objection, if your
Because
lordship
this
kindly
is
grant.
contradictory kind of,
Malad.
I mean,
Malad,
372 and 378, there are certain
Lordship.
gray areas.
My lord, if your lordship kindly be permitted, my objection may kindly be.
In a special leave,
Yes.
how do you have the right of
No,
audience?
my lord, I do not. I do not.
You'll have your chance before the appropriate
Last.
court. Allow, special leave allow. We produce the judgment in connection with.
Grateful.
Leave granted.
Grateful, your lord.
It's always better to fight out on merits rather than on technical issues.
My lord, I.
Next.
Grateful, your lord.
Well, lordship, I'm led by.
The applicant petition, this application has been filed under section 378 clause 4 for a special leave, my lord, to file an appeal, my lord.
Voice is
For-
breaking. Your voice is breaking.
This is an application under section 378 clause 4 of CRPC. They are applying for leave to appeal, my lord. But and two applications, two connecting application was filed along with the main applications were one is filed for continuation of delay by 185 days, word, and another application is filed by the applicants to represent to file these applications and to proceed the case because the original complainant died in the state during the pendency of the complaint case. But in terms of the
What is CRAN 2 is the special leave. Yes. CRAN 1 is the delay continuation.
Continuation of delay.
delay, my lord.
My lord, notice has been served upon the state, but the thing is, my lord will certainly consider this is a CR case, complaint case.
We have
So
served.
whatever fight has to be done by the
Yes.
party.
We have served.
You serve the
So
complainant.
the opposite
The
party,
opposite party,
they
yes.
appeared first.
We have served.
States, this state has no role to
No.
play.
We have no case study, nothing.
That cannot be.
Right. Performer dependent.
This is served.
Served.
Proforma dependent. CRAN আছে। Affidavit of service, none appears for the private opposite party despite service, private respondent. Private respondent despite service. Paragraph, the appellant seeks, appellant slash applicant seeks condemnation. Filing the application. Paragraph, withdrawal is being shown. The application ran, one is the condemnation application, right?
Lordship, lordship.
One of twenty 2023 is allowed. Delay in filing the application being CRM within bracket SPL bracket closed 3 of 2023 is condoned. Paragraph, peruse the judgment, special leave alone. Leave granted. To proceed with the leave application. So CRM along with tutor plan allowed.
Good.
Next.
Grateful, lordship.
Application against the order. It's an appeal against the order of acquittal. And I'm the de facto complainant. I have served twice, and the last occasion there was.
There's a delay.
My lords.
There's a delay.
My lords. 200 and odd days. I served twice. Last occasion, it was a direction upon the state to inform the accused persons. They might have done. I'm praying for delay be condoned and appeal should be admitted. Unless I've been waiting for it.
Has the state, sir, there was a direction upon the state.
Mr. Neela Chakraborty is appearing for the state. Your lordship will find the appearance. He appeared. Unless for a year I've been waiting.
No, I'll pass it over. When can you come?
My lord, what can be done is, my lord, we need one intimation whether the IO has served or not. Can you keep it
Yes.
tomorrow?
yes. Not
Kindly
today.
keep it
Not
tomorrow,
today.
so they can.
Please
we
come back
can
with the
inquire.
invitation
Yes, my lord,
tomorrow.
Can inquire.
And tomorrow I hope you'll not be busy with the elections.
We are not, my lord.
We are not, we are.
I am from Calcutta.
Yeah.
I only need the intimation that it is served. I'll pass
Yes, my lord.
necessary order.
We have to cross check the IO, my lord.
Next.
14, my lord. But 14, my lord, the admission was already done, my lord, admission, and there is a direction to call for the record. Till date, my lord, record is not called for, my lord. Admission fee দিয়েছে।
Oh, record has not been, has not come as yet.
Secondly, my lord, kindly direct to serve the copy to the.
Issue usual notice, there is a direction for service.
Okay,
These are the normal orders. Issue usual
effect
notice
of
and call
and
for the
also
reports. These are
also the
there.
accused,
Yes,
also the accused person.
so please serve.
এই লোয়ার কোর্ট রেকর্ড আসে নাই।
The appellant is directed to serve copy of the memo of appeal along with annexure thereto upon the respondents and file affidavit of service on the agenda date. Paragraph trial court records be called for.
Get comment. Matter placed before the next appeal. Matter placed before the next appeal.
The matter be placed before the next,
Yes.
unless the records come, it's difficult. Paper books need to be prepared. Oh, at the trial court records be called for. Paragraphs, paper books be prepared within 4 weeks, from receipt of the trial court records.
Okay.
I'll not place it before the next circuit. Mention after this is
Yes.
ready. We'll enter the next circuit. But no use placing it before the next circuit. Next,
Lordship, I am appealing for the petition.
which matter?
Item number 15. Lordship. Lordship, this is a NI Act matter. Between the petitioner and the opposite party, there is a business relationship. The opposite party has given 2 lakhs rupees to the petition. On 17/8/2020, through bank transfer, petitioner has returned 1,50,000. On the next day, a blank check was given to the opposite party. On the next day, the opposite party submitted the check before the bank, and this case has been initiated. Now the situation is, Lordship, warrant has been issued against the petitioner. He was granted bail. He appeared, and now warrant has been issued against the petitioner, and subsequently a talk of compromise is going on, Lordship, between them. Lordship, I am praying for a limited stay of the instant case and the warrant. And Lordship, kindly allow me to serve a copy upon the opposite party, and let me come back up thereafter. That due is 2 lakh, and I have paid 1,50,000. Through bank transfer, page 14, I have annexed. Page 13 and 14, annexure P1.
When was the warrant issued?
Warrant issued, Lordship, on, Lordship, just the 12/7/2024, 12th July.
Where is that order of 12th
12th
July?
July.
Yes.
Lordship, this is in the, that is in the certified copy, probably, Lordship, I am telling.
That's why I'm saying.
Lordship.
After
Lordship.
10th June, next order you have given is 22nd August.
No, Lordship, page number 29. Lordship has got it.
Since warrant has been issued, surrender before the trial court.
Lordship, kindly give me a limited stay in this matter.
I will
I'll
stay the
ser-
warrant for a limited period, surrender within 7 days.
Lordship, can it be on 15 days? Because the petitioner is from Malda. He has to surrender before Jalpaiguri.
Very well, surrender within 15 days. I'll stay the
Lordship.
warrant for a limited period.
And the instant case, Lordship, kindly stay the instant case also. Because I have already paid 1,50,000.
Case cannot be stayed for at the moment. Surrender,
Lordship,
let it be regular.
for
If the matter is amicably settled, file a joint application, that will solve the issue.
Lordship, that will do. Lordship, kindly stay for a limited period, Lordship, for 2
Not
weeks.
the case, no, not the proceeding. When is the next date?
Next date was, Lordship, in the November. Thereafter, Lordship, the 25th November date was.
Cannot be the
But
next date,
thereafter,
was the earlier date after that?
after that, Lordship, I have asked, but he has no information, the petitioner.
Please surrender, I'll stay the warrant for a limited period. And I'll allow
Lordship.
you to remain on the same bond.
Lordship.
The petitioner seeks quashing of proceeding, being CR case number 424 of 2020, pending before the learned judicial magistrate, second court, Jalpaiguri, on the ground that out of the entire due amount of rupees 2 lakhs, he has already paid rupees 1,50,000. That is your case, right?
Lordship.
1,50,000. And a talk of settlement between the parties is in progress. Paragraph, learned counsel for the petitioner submits that warrant of arrest has been issued against the petitioner
On 12th July.
by the learned trial court on 12th July 2024. Paragraph. It appears from the record that the petitioner was on bail all throughout, and warrant of arrest was issued against him on 12th July 2024 due to his absence before the learned trial court. Stop. The petitioner undertakes to surrender before the learned trial court within 2 weeks from date. If the petitioner surrenders before the learned trial court within 2 weeks from date, the learned trial court shall permit him to remain on the same bond. Paragraph, in the event the petitioner does not surrender before the learned trial court within the stipulated time frame, the learned trial court shall be at liberty to take necessary steps against the petitioner in accordance with law.
Lordship, can it be 3 weeks, Lordship?
No,
Next week is the holiday.
No.
Next week is the holiday, Lordship. 4th, the court will open.
This is before the
Fourth,
judicial magistrate. And this
Lordship,
is Jalpaiguri court.
Lordship, 4th, the court will open. That it is within the holiday then. After 4th, any day.
Today is 18th, 25th. Next Wednesday is?
Next week is the holiday, Lordship. From next week.
Criminal court will not be, will not have a holiday for the winter, isn't it?
Lordship, after 4th, any day.
The criminal court will remain closed only on 25th December.
Lordship, after 4th, any day.
No.
No, Lordship, not.
Then please do not make these submissions.
Oh, Lordship, grateful. Lordship.
I come from the district judiciary, sir. So please do not
Lordship,
make...
I know, Lordship. I beg your pardon, Lordship. I have argued that.
Okay. The petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Paragraph, the matter be placed before the next available circuit bench.
Grateful, Lordship.
Next.
I'm appealing for the petitioner lordship. Come before your lordship for quashing of a proceeding under section 406, 420, and 120B of the Indian Penal Code. Lordship, the entire dispute is civil in nature. What has happened that, Lordship, the petitioner number 1 to 4, they are the bona fide purchaser of a landed property. And the petitioner number 5 is the attesting witness in the deed of registration. And Lordship, before the purchase, the petitioner number 1 to 4, they published notice in the newspaper, 2 newspapers, they published notice that we are going to purchase. If any objection is there, please come forward. Nobody came forward. Civil suit was filed by the de facto complainant. And after that, this FIR has been initiated, alleging that we have forged the registered deed and we have purchased this property, Lordship. The entire dispute is civil in nature, Lordship. Kindly see the page 64 to 75. This is the plain, Lordship, and
Page,
64, Lordship.
the civil suit is pending.
Yes, Lordship.
64 is the order sheet.
Yes, 64 is the order. 65 is also the order, Lordship. And the plaint is from 67.
There's a status quo order, right?
Yes.
The civil suit was also filed by the opposite party
De facto complaint.
against Arup Das is the plaintiff. No, this is against whom?
Arup Das, Pradeep Das, and Ratna Das,
So
Lordship.
they are not the petitioners.
No,
here.
they are not the petitioners.
Where is the plaint?
67.
So this is not against the petitioners.
Lordship, Arup Das is the seller. Arup Das sold the property to the petitioners. They are all brothers, Lordship. Arup Das, Pradeep Das, and Ratna Das. They are all brothers and sisters. And out of them, Arup Das sold this property to the,
He claims to be a co-sharer.
yes,
The opposite party claims to be a
Yes.
co-sharer, right?
Arup Das sold this property to this petitioners number 1 to 4, Lordship. Deed of conveyance, starting from page 13.
13(1)(3).
1-3.
Where is the complaint? These defendants have not been made parties in the complaint.
No, Lordship.
Where is the complaint?
Complaint is the last page, Lordship, certified
Certified
copy,
copy.
last page.
I'll stay this, serve and come.
Lordship. Keep it.
The petitioners seek quashing of GR case number 4694 of 2024, pending before the learned chief judicial magistrate from Jalpaiguri. Paragraph, learned counsel for the petitioners submits that petitioner numbers 1, 3, and 4 are purchasers of the plot in question, and petitioner number 5 is the
Attesting witness.
attesting witness to the deed of purchase. The private opposite party claims to be a co-sharer in respect of the property and has filed a civil suit against the vendors of the petitioners, comma, which is pending, stop. An order of ad interim injunction, an order of ad interim injunction in the form of status quo has been granted by the civil court. The petitioners are bona fide purchasers for value and the allegations made out against them in the FIR are false and frivolous. Paragraph, it appears from the material on record that the matter needs to be heard on merits. Paragraph, the petitioners are directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the urgent date. Paragraph. They are the only accused, or there are other accused
No,
persons
they are
also?
the only.
Paragraph, further proceedings of GR case number 4694 of 2024, pending before the learned Chief Judicial Magistrate, Jalpaiguri, being stayed till 31st January 2025 or until further orders, whichever is earlier. Paragraph, the matter be placed before the next available circuit bench.
Deeply.
Proceedings to hold. Only warrant as well. Oh, at the line will be the warrant will be stayed till 1 to 4 which numbers 1 to 4
Lordship,
Next.
item number 4, both sides are present.
4,
Yes.
the bail application.
Yes.
Reading 4. You have the CD with you?
Lordship, the allegation is under section 14 and 15 of the.
May I permit, Lordship, this petition is not maintainable, Lordship.
Why?
Because the initial case was started under section 14 and 15 of POCSO Act. Lordship, but charge is submitted under section 6 of POCSO Act.
So division bench.
Yes, Lordship.
Where is the charge sheet?
It's written in the record.
Yes. Go to the infect room. Since charge sheet has been submitted against the petitioner under section 6/10, 12, 14, 15 of the POCSO Act, the matter is released due to lack of determination.
Deeply up.
Next,
Lordship, because it has to be mentioned before the division, may I file another copy?
another?
Another copy, a single bench copy is there. So liberty may be given to file another copy.
You can do that before the division bench, after you mention.
Deeply up.
The liberty will be granted by the division.
Item number 17. I am for the petitioner.
Lord, in this matter, the petitioner is praying for setting aside the order dated 14th of June 2024, my lord, whereon the petitioner bail was cancelled, my lord, and warrant has been issued.
You to
Subsequent.
serve and come back.
No, state is present. My lord, it is a single
Yes,
court matter, my lord. Lord, I have to serve.
yes. You're asking for a setting aside an order of cancellation of bail. The state needs to know. Not only the state, where is the private, the de facto complainant?
Madam, is a case of NDPs, Madam, state is sufficient.
Suo motu complaint,
So, by the police.
serve and comment.
Madam, tomorrow,
No, no.
or day after tomorrow. My lord, in this matter, there is a direction to appear before the police authority once in a week. But my lord, the learned advocate of the learned lower court, my lord, did not advise him to appear before the police station once in every week. My lord, for this reason, the investigation officer has been filed an application for cancellation of bail, my lord. And subsequently, the bail has been
Friday,
cancelled.
Friday.
Great.
The petitioner has assailed the order passed by the learned additional sessions judge, first court, Cooch Behar on 14th June 2024 in NDPS case number 48 of 2023. Whereby the learned court has cancelled the bail granted to the petitioner earlier. Paragraph, the petitioner is directed to serve copy of the application along with annexure thereto upon the opposite party and file affidavit of service on the agenda date. Paragraph, let the matter appear under the same heading on 20th December 20.
Good.
Next,
Lordship, on Passover matter.
I'll call after everything is over.
My lord, I am led by Mr. N. Bhattacharjee virtually.
Where is Mr. Bhattacharjee?
My lord, maybe kind enough to grant me a short passport.
He's not there online. Passed over. Passed over.
20, I'm for the petitioner, madam.
Hello, my lord, I'm for item number 19. I
Yes,
was off.
for what?
I'm for the petitioner. Item number 19, I'm for the petitioner.
Telling you 90, I'll just deal with 90. Yes. 19. Okay, Rafi?
My lord,
Yes.
my lord, this is a commercial transaction, my lord, and there is a business relation between petitioner and the opposite party. If my lord will peruse the complaint of the petitioner, the opposite party on the basis of which the FIR charge sheet has been filed, admittedly there has been a part payment, my lord, and in my humble submission, my lord, the ingredients of section 420 cannot be ignored in such case. The petitioner is already enlarged in bill, my lord. As per it is admitted that the petitioner has made some certain part payment, and that's when my humble submission, my lord, they cannot the 420 does not lie, and I'll be paying for quashing of the entire proceeding. It is a it is attached with the certified copy. The melody filed with the at the end of the certified.
A minute.
Yes, melody.
So out of the 19 lakhs and all, you've paid only 2 lakhs. Right?
My lord, it is their admission that they have paid this much back, but according to my submission, my lord, I have goods, and for that the challan has been attached. They have the challan has been issued against the company Build World, which is the opposite party's company, the proprietorship, and they have not stated that. Even if we are to take that their complaint on.
Charge sheet has been submitted.
My lord,
Charge sheet has been submitted. There is some technical.
30th of September 2020. But 30th of September 2024 charge sheet filed.
And you're on bail?
Yes, my lord. I was enlarged on bail on 24th of September 2024.
When is the next date before the trial court?
My lord, the next date is 15th of March 2025.
Oh, so no stay is required. Serve and come back.
My lord, but they has this no ingredients of 420 is not attracted. My lord, kindly appreciate.
Maybe when the matter is dealt with on merits, it will be considered. You don't require a stay. Nothing is going to happen before March, isn't it? So please serve. The petitioner seeks quashing of GR case number 3313 of 2024, pending before the learned Chief Judicial Magistrate, Jalpaiguri, on the ground that there was a commercial transaction between the parties and the petitioner has made payment of substantial amount due. Stop. There is no ingredient of offense under section 420/506 of the Indian Penal Code against him. Paragraph, the petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Paragraph, the matter be placed before the next available circuit bench.
My lord, may sequence follow indulgence, my lord. My lord, if the matter is not taken up of 15th of March, my lord, can I be granted liberty to mention this matter and pray for stay of the proceeding, my lord?
Mention before the next circuit
My
bench?
lord, liberty may be
Upon
granted for that.
service? No,
Upon
not
service,
necessary. Yes, it can be taken up in January itself, isn't it?
Yes, my lord, but if the matter is not taken up of March, then only then I'm seeking, my lord, that liberty may
There
be
cannot
given
be any
for.
advance booking, sir. If it is not taken up in March, the court will consider. Next.
Yes. Stay of warrant, my lord, warrant was, there is a bail granted, my lord, non-FIR, no steps, thereafter warrant was issued.
It was on bail earlier.
Earlier on bail.
What are the allegations?
But, I don't know,
376/120. Where is the bail order? Have you annexed?
Not annexed, my lord, if your lordship kindly please the, my impugn order, but it would be one repeated, my lord, he was on bail, my lord. Should he start proceedings, should he under.
29th November.
Yes, my lord, 29 November, next date on 4th of January 2020.
Surrender. I'll stay the warrant for a limited period.
Remain on same bail, remain on earlier bail.
Within 1 week?
Yes, madam.
The petitioners have assailed the order passed by the learned Chief Judicial Magistrate, Jalpaiguri, on 29th November 2024 in GR case number 1660 of 2017, issuing 17, directing issuance of warrant of arrest against them. Paragraph, it appears that the petitioners were on bail and failed to appear before the learned magistrate on 29th November 2024 without steps for which warrant of arrest was issued against them. Stop. The petitioners undertake to surrender before the learned magistrate within 7 days from date. Paragraph, if the petitioners surrender before the learned Chief Judicial Magistrate, Jalpaiguri within 7 days from date, they shall be allowed to remain on the same bond. Paragraph, in the event the petitioners fail to appear before the learned magistrate within the stipulated time frame, the learned magistrate shall be at liberty to take necessary steps against the petitioners in accordance with law. Paragraph, the warrant of arrest issued against the petitioners on 29th November 2024 be stayed till today is 18th, so it takes us to 25th, stayed till 30th December.
My lord, one instance, my lord is disposing this application, my lord.
Yes.
My lord, kindly give the, my lord, appearance for the state, my lord. My lord,
Not necessary.
My lord, kindly.
No, no. Yeah, I'm giving it in all the cases. There's no direction for service, nothing. Disposed of urgent certified website. Next.
So down for the victim. Well, initially I am the husband. My lord wife, my lord my lord filed a DV case, my lord, where my lord the wife obtained an ex parte order against which husband filed an appeal under section 29, and that order has been set aside. It has been sent for him for fresh hearing, and that DV case is at the stage of submissions of
Affidavits.
assets and liability. On the other hand, my lord, the wife also obtained an order of ex parte order in a 125 proceeding. My lord, in that is behind the back of the petitioner, your lordship will get from the order sheet that the service was not affected. Subsequently, an execution of case has been filed by the wife, and there the warrant has been issued. My lord, the petitioner has.
So in the DVI proceeding, you're not paying anything, right?
My lord, DV is at the stage of
Okay,
declaration.
so no payment is being made
No,
in
no,
the DVI.
declaration of assets and liability.
How much have you been directed to pay?
My lord, in DV.
No, DV, there is no direction.
My lord,
In the maintenance case, 125.
my lord, maintenance case lordship, I have the order certified. My lord, subsequently, I have got this order of under section 125. Here, my lord, he has been directed to pay 20,000 per month from the date of filing. Now, my lord, petitioner has the intention to, my lord, discharge his duties. Now, my lord, because of my lord, of the warrant of arrest, my lord, he is unable.
How much have you paid?
My lord, I have not yet paid, lord.
You have the intention, but you have not paid.
My lord,
What does
because
that
my
mean?
lord, it was not lordship kindly see the orders for my petitions, my lord. The certified copy of the orders, the warrant against the last order kindly see lordship 13th of November 2024. Warrant against the opposite party not yet been executed. So my lord, petitioner was unknown about this 125 proceeding as well as this execution. My lord, he want to surrender and he will pay. Lordship, kindly, I am praying for the my lord protection so that he can surrender and pay lordship. Otherwise, keeping him in custody will not serve
not
the purpose, my lord. And my
So
lord,
you are undertaking to comply with this order, right?
my lord, yes, my lord. He will, my lord, discharge my lord as much as he can. That is to be decided.
There lies the difficulty.
My lord, let him surrender.
Please show
lordship.
me the order, the ex parte order.
Yes, your lordship. The ex parte order, lordship, it is started from lordship, I'll say. This is the certified form. It is not annexed since I have got it subsequently.
What is this extension of interim bail that is going on? In the execution case, 198?
Yes, my lord, it is in respect of the police officer who, my lord, did not execute the warrant of arrest. Therefore, warrant of arrest issued against him also. Lordship will get this from the earlier orders. Lordship will get it from the order of 8th of January 2024. Hence, issue warrant of arrest against SDPO immediately as per the provision of section 349. That is in respect of their warrant of arrest, my lord. Because they did not execute the warrant of arrest in respect of the petitioner, therefore warrant of arrest issued against them. That is the this extension in respect of that, lordship.
You've come up with after the matter has become complicated.
My lord, this
Isn't it?
My lord, this has not been issued, my lord. The ER of WA was not, my lord, executed by the authority concerned. My lord, as soon as I came to know, my lord, I have filed this application and I want to, my lord, surrender for this learned court, lordship. My lord, lordship, kindly consider. If I be taken to the custody.
Only surrendering will not really help. You have to pay.
My lord, yes, lordship. My lord, unless, my lord, I surrender, my lord, how can I pay, lordship? This period of stay, lordship, I am surrendering and I'll.
Till disposal of the revisional application, you don't need to pay the arrears, but continue to pay the 20,000 per month
Lordship,
from December.
Lordship.
And file an application for bail, I'll stay the warrant for the time being,
My lord, your lordship.
since you are not on bail at all.
Lordship, my lord, my lord, today your lordship is staying the audit warrant, lordship.
I will stay the warrant of arrest for a limited period,
Lordship.
surrender within 7 days,
Lordship.
file an application for bail, let the magistrate consider
Lordship.
that, and continue to pay rupees 20,000 per month
Lordship.
from December.
I'm extremely
Yes.
grateful, my lord.
The petitioner has assailed the order passed by the learned judicial magistrate, third court, Alipurduar, on 1st February 2024 in MR execution case 198 of 2024, directing issuance of warrant of arrest against him. Paragraph, learned counsel for the petitioner submits that an ex parte order was granted to the opposite party by the learned judicial magistrate, third court, Alipurduar, on 8th June 2022 in MR 91 of 2021, directing the petitioner to pay maintenance to the tune of rupees 20,000 per month to the opposite party with effect from 25th March 2021. The petitioner was not aware of the said order and therefore could not comply with the same. Stop. Warrant of arrest has been issued against the petitioner on
1st of February 2024.
1st February 2024. The petitioner undertakes to pay maintenance to the opposite party to the tune of rupees 20,000 per month with effect from December 2024. Paragraph 24, and surrender before the learned trial court within 7 days from date. Paragraph, if the petitioner surrenders before the learned trial court,
My lord, he is staying at Andhra Pradesh. Can it be?
2 weeks,
2 weeks, lordship.
within surrender or within 2 weeks from date. If the petitioner surrenders before the learned trial court within 2 weeks from date, 2 weeks from date, and files an application for bail, the learned trial court shall deal with the same in accordance with law. Warrant of arrest issued against the petitioner on 1st February 2024 be stayed till 2 weeks takes us to stayed till 6th January 2025. Paragraph. The MR execution case being number 198 of 2024 be stayed till 31st January 2025 or until further orders, whichever is earlier, subject to the petitioner paying rupees 20,000 per month as maintenance to the opposite party, the maintenance for December 2024 being payable within then after that, within the 7th day of each month.
Each month, yes, lordship.
24 December 2024, and the subsequent amounts being payable, subsequent amounts for each month being payable within the 7th day of the month.
My lord, one.
Sorry, Mr. Director.
Is 198 of 2022, lordship. And MR execution case is 198 of 2022.
Please correct the cost title. You stated 24 in the cost title. Huh? It's 24. Oh, execution is 2022.
My lord,
Please
I'm
correct the
correcting.
cost.
It's my mistake, Lordship. I'm sorry, my lord.
I was following that actually. Even in the prayer portion, everywhere it's 24.
I'm correct.
2022 করুন।
It's 2022, Lordship.
198 of 2022 একদম শুরুতে করুন on prayer of the petitioner, liberty is granted to correct the cause title and the prayer portion of the application.
Grateful.
The petitioner is directed to serve copy of the application along with annexure thereto upon the opposite party and file affidavit of service on the adjourned date. Paragraph, the matter be placed before the next available certificate. I would request you to come back with a supplementary affidavit annexing these documents. Because when the matter is taken up for hearing, this will be
125,
required.
That order of
Yes.
125, yes, your lord. Gave back the certificate.
ওখানে যেখানে ইয়ে করলো, you can take this back.
Yes.
Please come, file copies with the supplementary.
Supplementary. Okay.
We would correct the cause title of the যেটা বললাম and file a supplementary affidavit annexing relevant documents. I've granted you liberty to file a supplementary affidavit also.
Lord, I'm there. Grateful.
Next. As well as the supplementary. Next.
So I have challenged the impugned proceeding initiated under section 498 and other provisions of the law. So there is a predominant case that a marriage was a case in the like that the marriage was solemnized in the year 2016. Subsequently, mutual divorce was filed by the parties lordship on 22nd of November 2019. That was not concluded, lordship. Subsequently, first 498 proceeding was lodged by the wife, and that was charge sheeted. I took bail. Subsequently, that was interfered by this honorable court, and it was stayed. Second, thereafter, second 498 proceeding was initiated. That was also intervened, and it was also stayed. It appears with the course of time that series of litigation was filed by the wife against the husband and his entire family member. The honorable division bench in dealing with the two appeals had dealt with elaborately and decided that this couple need to be, the issue need to be sent to the mediation. Accordingly, the mediator was appointed and the petitioner both the parties was directed to appear before the mediation at Calcutta. Petitioner appeared thrice. That wife couldn't appear. And thereafter, the mediation process was failed initially, pursuant to the direction of the honorable division bench. Division bench recorded the entire order sheet. So I annexed all these things. Subsequently, when the coordinate bench of another division bench has also recorded the entire factum of frustration of the mediation, and thereafter, second mediation was appointed. Mediator was appointed at Jalpaiguri. Now that mediation process has not yet initiated. I, being the advocate on record, had requested the learned register to get it disposed of the mediation process so that it can be it attains the finality. There are series of litigation pending, including the custody battle with the child and the section 26 application and other pending process also. Now on this backdrop of the case, the two consecutive 498 proceeding has initiated. I have asyled by this revision, and secondly, and item number 24 also. This is how the life is being ruined by the wife.
This is the second proceeding.
This is the third.
Third.
And the item 24 is the fourth one within 3 months.
Let me stay this for the time being. I'll request the registrar to initiate the mediation.
Lordship.
Yes.
Lordship.
Learned counsel for the petitioner submits that the petitioner is the husband of the second opposite of the private opposite party, stop. Due to disputes and differences between the parties, comma. A suit for mutual divorce was filed, which did not finally, that was abandoned,
No, it was pending.
which is still pending.
Still pending.
Which is pending. Which is pending, stop. Two earlier complaints under section 498A of the Indian Penal Code were lodged by the private opposite party They are stayed
Yes, both.
against the petitioner, which have been stayed by intervention of this court. Stop. The dispute was sent for adequately. The parties were sent for mediation, which failed. Stop. There was a direction for sending the matter for mediation a second time. Stop. But the mediation process has not been initiated till date. Stop. The present proceeding being GR case number 2895 of 2024 is the third complaint lodged by the private opposite party. The petitioner seeks quashing of the ডেটটা যেখানে বললাম না, the present proceeding being GR case number 2894/2024, ওখানে একটু add করুন, pending before the learned additional chief judicial magistrate, Siliguri is the third. The petitioner seeks quashing of the proceeding and a direction for initiating the mediation process. Paragraph. Upon consideration of the material available on record, this court is of the view that the mediation directed by the coordinate bench of this court. It was a coordinate bench of the,
Yes.
of the
No,
division
coordinate
bench,
bench, coordinate bench.
not the division bench.
No.
Coordinate bench of this, by this.
Sorry, division bench, division.
Mediation process, directed by this court, না কিছু বলে না, by this court ought to be initiated at the earliest. Paragraph. The learned registrar, circuit bench, Jalpaiguri, is requested to take necessary steps for initiation of the mediation between the parties at the earliest. Paragraph. Further proceedings of GR 2895 of 2024 pending before the learned additional chief judicial magistrate, Siliguri, be stayed till receipt of mediation report copy service direction, please. A copy of the application be, the petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the agenda date. I'm not placing this before the next circuit because the
Yes.
mediation, let the mediation take place.
Yes. Item number 24 is the another GR case number.
That is the fourth case,
Fourth
right?
case.
The remaining will be the same.
Yes, yes.
Let me add a line, liberty to mention upon
Yes, yes.
completion of
Yes,
mediation.
Yes, that will be
Okay.
correct.
Liberty to mention upon completion of mediation. Conclusion, completion. Conclusion of mediation. Conclude. Of the mediation proceeding.
Only the GR
24
case and PS case number will be different.
24. 24. This is 22. 24 টাকে দিয়ে দিন, 24 the same parties.
Same part.
এটা GR case number 4096 of 2024. 4096 of 2024 pending before the learned additional chief judicial magistrate, Siliguri. আর ওখানে যে third, fourth complaint হয়. 3 earlier complaints, ওখানে যে 2 বলেছি, 3 earlier complaints আর 4th complaint. officer. The same order in this.
Great, grateful. Lord.
Yes, now 23.
23, I'm for the petitioner, Lordship. But you have assigned the impugn proceeding initiated under section 12 of the Domestic Violence Act. Lordship, this is almost a similar case. Lordship, that the petitioner married the opposite party on 2nd of May 2014. After 27 days after their marriage, the petitioner discovered that that his wife has a pre-existing marriage, having his husband alive. Out of this, the discordance and dispute, she left away from her own matrimonial home, Lordship, voluntarily. Thereafter, petitioner lodged a general diary entry against the wife for missing. Subsequently, cheating case was registered by the petitioner against her wife, and that was ended with a charge sheet, positive charge sheet, and it is trial is pending. Now the 498 proceeding was initiated by the wife after departing from his matrimonial home out of vengeance. So that was that 498 proceeding was with respect to a particular date, that is on 17th of May 2014. And this particular 498 proceeding was concluded with the acquittal of the petitioner on merit. Proceed that apart, proceed and suit for nullity on 2 occasions was filed, initially before the learned Munsef court. That was ultimately withdrawn because of lack of jurisdiction under the heading of title suit. Subsequently, it was properly filed before the learned sessions court, district judge, under section 11 of the Hindu Marriage Act. That is on the fag end of the trial. In these premises, in the year 2015, after 1 year and 6 months from her left out, this domestic violence proceeding was initiated. My humble submission is this: when the cause of action of the domestic violence is the same, that is the 17th of May 2014. Now, my humble submission is that recently, when I got acquitted from 498 proceeding, what is the utility of this carriage of impugn proceeding? There is no, and not only that, the entire proceeding has been frivolously lodged by making out no cause of action in genuine terms under the Domestic Violence Act. I am relying upon the impugn order of acquittal that is attached with my application at page 68 to 72, and that apart, Lordship, I have also attached the application under section 12 of the DBR. That is at page 56 to 62.
I'll stay the proceeding, serve and come.
Yes, Lordship.
The petitioner, who is the husband of the opposite party, seeks quashing of proceeding being miscellaneous case number 138 of 2015, pending before the learned Judicial Magistrate, 4th Court, Siliguri. Stop. Paragraph. Learned counsel for the petitioner submits that the parties were married in 2014.
No. Yes, 2nd of May 2014.
Married on 2nd May 2014, and on 29th May 2014, the petitioner found that the opposite party had a subsisting marriage. The petitioner filed an application seeking nullity of the marriage, which is pending before the appropriate forum. A complaint under section 498A of the Indian Penal Code was lodged by the opposite party against the petitioner and his family members.
Yes.
When was it lodged?
It was lodged on
in 2014. On 4th June 2014.
Yes.
And was registered as GR case number 2724 of 2014. Stop. by a judgment delivered on 28th February 2024, the petitioner and his family members were acquitted. Stop. The present application under the Protection of Women from Domestic Violence Act was filed on
uh,
9th October 2015.
yes, 9th October 2015. 9th October 2015, yes.
A learned counsel submits that since the petitioner has been acquitted from the allegation under section 498A of the Indian Penal Code, and also as the case claiming nullity of marriage is at its fag end, the present application under the Protection of Women from Domestic Violence Act is not maintainable. Paragraph, the matter needs to be heard on merits. Paragraph, the petitioner is directed to serve copy of the application along with annexure thereto upon the opposite party and file affidavit of service on the adjourned date. Paragraph, further proceedings of miscellaneous case number 138 of 2015 pending before the learned judicial magistrate, 4th court, Siliguri, be stayed till 31st January 2020.
3rd of February is the next date. So it can be covered by till February.
3rd of February is the next day.
Next day.
Till 28th February 2025 or until further orders, whichever is earlier. Paragraph, the matter be placed before the next available circuit bench.
Wait.
Next. Passed over. You're appearing in 25?
My lord, may we permitted a short pass over?
Your lordship, I'm praying for a short passover.
Passed over. Great. Passed over. 27?
27.
Not correct. Passed over.
So it can be taken up a bit later, lordship. I get.
Passed over.
Passed over, sorry.
And 29 praying for short Passover, my lord.
Passed over.
30 minutes I am appearing for the state, my lord. 29.
People are appear on behalf of the petitioner, my lord.
Yes.
My lord, I'm praying for passing a proceeding. I was under 341, 323, 325, 34 of the Indian Penal Code. Well, I am the security guard of a Malad check post, Ithalbari check post. Well, kindly see after page 30 is the Malad written complaint. But may I read, my lord?
Give me a minute, please.
My lord, it said, Ami Sohidur Hossain, such and such. Mother Ami, Malad, the vehicle number is
Have
from
you served?
Assam.
Where is your service? On the
Malad,
private.
I serve to the state as well as the opposite party.
Where
Well,
is your
opposite.
affidavit of service?
Like someone is present in there, malad.
No, there is no one for the private opposite party, not even for you. I would like to see the affidavit of service first.
Then malad, not today, malad, I'll come back tomorrow, malad. Well, I have served, malad.
But I have to collect the case diary also, as because malad, the
State is appearing.
Xerox copies they have supplied. Malad, quite illegible.
When can you come?
Malad, it's from. Let me take my.
Bidpara police station, my lord. Day after two.
Friday.
My lord, only one thing, my lord, private respondent appear, my lord, is service returned as insufficient address, my lord. My lord, kindly directed to state to sub, my lord.
I need to see the affidavit first, sir. Let
My
it be
lord.
not today only, let him come back with the affidavit
My-
because private
my lord.
respondent. Sir,
Yes.
My lord.
Private respondent
No
is
need.
is a truck driver, my lord. Maybe.
Can be
Uh,
served through the state, let us see.
I will try.
Let the
Get through.
affidavit come first, then
Yes,
I'll give you, I'll request you to serve.
Yes.
Not today.
Great, great.
Passed over.
My lord, item number 31, I am for the petitioner.
Yes,
My lord, am I audible?
you are.
My lord.
Yes.
My lord, I have prayed for extension of interim order. My lord, the interim order, parent interim order was granted by your lordship. My lord, here in this case, the petitioners had been made accused. Petitioner are the professors and he is the dean of, my lord, of one of the universities. My lord, they have been made accused of the, under the, one of the provisions is prevention of scheduled caste and scheduled tribes, prevention of atrocities act. My lord, the application for extension of interim order has been filed within time.
Where is your service?
My lord, my junior is probably present in court, my lord, Hillol Shah Poddar.
Where is he?
He is not in.
No, he's not here.
Oh. My lord, opposite.
He's not here.
My lord, can it be short passover then?
Yes, yes, I'll pass it over.
My lord, I will inform you. Grateful to your lordships.
Next. Passed over.
Lordship. And I have instruction.
It's at the motion stage, right? Uninvited. Yes.
More the media. Lordship, kindly see.
No, opposite party number 2 appeared on the earlier occasion.
Yes, Lordship, without, since inception,
He's there.
Lordship, sees page 83 first.
State case or a complaint case?
No, sir.
This is a
Lordship,
complaint case. So why will you deprive the state, serve the state?
no complaint will serve it. Only motion say the admission, then. Lordship, only one thing,
Already
only
on
one thing,
record.
only one thing, Lordship.
Yes, yes.
Page 83, the certain documents were filed by my junior brother, which were sent prior to submission in the office through computer email. And those copies has been served by my brother, which does not contain his signature. Lordship, please allow us to, as because this was a motion stage, to file
Supplementary.
supplementary affidavit with those documents. The CA signature, partner signatures are not there. We have filed the documents and now those documents, signatures are there.
Yes, what is the matter about?
Lordship, kindly comes to the last part, the certified copy. One FIR has been lodged by Poonam Periwal against 3 persons, out of whom the petitioner is one. Read the certified copy I have filed. If Lordship goes through the entire FIR, no whisper of any act committed by the present petitioner. All the allegations against Sushil Periwal and Lokesh Periwal, they are none of partners of that business firm.
Charge sheet has been submitted.
No, Lordship.
Investigation is going on. Main thrust of allegation is against the other two,
Other
Lokesh and
two.
Sushil.
Those 2 persons are not part and parcel of the company. Those are outsiders. My only.
And they are not before this court
No,
also.
no. My only contention is that, Your Worship, the petitioner here and the de facto complaint and another, three are the partners of the firm, having 33.33% share. So all the grievance, what they are saying, are matter of investigation, and police might have collected all those documents. But the allegation against me, that is the petitioner, is not there in the FIR. Another point is that by forging the signature, the KYC was obtained. That does not attract 420 and 400 lordship, because no gain is gathered by the party. Only for the sake of continuation of the partnership business account, they said if we take their submission to be gospel truth, that was done. So my humble submission is that no allegation against the present petitioner, and the other two are not part and parcel of business. And the dispute is regarding business transaction, that the brother of the de facto complainant, he took certain loan which had reflected in the balance sheet also. Now, when he was asked to refund the loan, this dispute cropped up.
Who took the loan?
The brother of the de facto complainant from the partnership business account.
Let me hear the.
The state is also required. How can it be? Because it's the
This is
admission
at the
stage.
admission stage. At the moment, I'll request you to serve,
Lordship.
number one.
Lordship.
Secondly, since I do not find anything much in this, let the investigation continue. I'll not
Lordship,
stop the
Lordship,
investigation.
we want-
No coercive steps against the
Lordship.
petition.
We also want that the investigation to continue.
Since the private supplementary affidavit filed by the petitioner is taken on record. Paragraph, since the private opposite party is represented, comma, the petitioner is directed to serve copy of the application along with annexure thereto upon learned counsel for the private opposite party in course of this date. Stop, the petitioner is further directed to serve copy of the application along with annexure thereto and as well as the supplementary affidavit. Upon the state and file affidavit of service on the adjourned date. Paragraph, the petitioner seeks quashing of proceeding being GR case number 2639 of 2024, pending before the learned chief judicial magistrate, comma, Jalpaiguri. Taking this court to the FIR lodged by the private opposite party, comma, learned counsel for the petitioner submits that the main thrust of the allegation of misappropriation of funds and forgery is against the co-accused Lokesh Periwal and Sushil Periwal, who are not connected to the partnership business wherein the petitioner, comma, the private opposite party and another are partners in equal shares. The brother of the private opposite party took loan from the partnership firm, and on asking him to repay the said loan, comma, the present complaint was lodged on false and frivolous grounds. Paragraph, the matter needs to be heard on merits. Paragraph, investigation of the case shall continue. Stop. No coercive steps be taken against the petitioner in connection with the present matter till 31st January 2025 or until further orders, comma, whichever is earlier, comma, subject to the petitioner cooperating in investigation.
Lordship.
Paragraph, the matter be placed before the next available
Should
circuit.
be supplement.
Take it.
Okay. Grateful, Lordship.
31st January 2025. The matter be placed before the next available circuit. Next. Oh. Yes,
Application as well as the supplementary.
Yes, all, we will say all.
I've recorded it.
Get supplementary না দিলে কি করে হবে? ওটা তো main তো ঠিক আছে।
Item number 34, I beg to appear on behalf of the petitioner. Lordship, I have served Lordship, but service has not yet completed, Lordship.
Next
Lordship.
circuit.
May I start the matter, Lordship, any
Without
stay?
service?
If,
Give filing. There was a direction for service.
Lordship, but if any stay may be granted.
Without service, it cannot. 2nd January it starts, so come back. Yes, there's a direction for service.
Lordship, we have already served, Lordship, but it has
Affidavit
returned
of service, it hasn't returned. So,
Return back, Lordship.
can you come back on Monday?
Lordship, after service.
After service, yes.
No,
Since service upon the opposite parties is not complete, comma, the matter be placed before the next available circuit bench. Next. Thirty-five, yes.
This is an application under section 482 CRPC seeking quashing of an FIR. FIR registered under Darling Southern Police Station, White, Southern PH.
Who are the persons just standing just behind you?
Southern PS case number 9/22 dated 17/1/22 under section 447, 354, 323, 423.
354.
354. But while the charges were filed,
It was dropped, right?
it was dropped. Now, the facts of the case in brief is that on 17/1/22, the de facto complainant, the respondent number 2 hearing, she lodged a written complaint to the effect that this petitioner, along with one Arjun Pradhan, criminally trespassed upon our land being plot number 160 part, damaged the fencing of the boundary and assaulted me and my old father while intervening their criminal act. Thereafter, after investigation of the case, IO submitted the charge sheet against these 4 petitioners and paid for discharging Arjun Pradhan. And Arjun Pradhan was 86 years old at that time, and presently he's 89 years old. And petitioner number 4 hearing is the son of Arjun Pradhan. Baba আর ছেলেকে involved করে দিয়েছে, and the petitioner number 1 and his 2 sons.
Where is the complaint? This is the complaint. What is the stage of the proceeding before the trial court?
Only few days back, plea was taken. All the sections are available and summons tribal. As because there was no escape from this honorable court, so the London magistrate took the plea.
Why are you asking for a quashing?
It's absolutely false case. No case has been made out. I'll satisfy your lordship.
I'll request you to serve and come back.
I've served.
There was no direction for service. How did you serve?
No, I think there was direction. I've served.
When was the direction given for service?
Last order, I think
The date of the order, I do not find any direction on record.
I have served them. And they have appeared yesterday. They appeared and they sought an adjournment.
Yes. Let me hear them.
There are certain other aspects also. One thing that she has categorically stated in her complaint
that she and her father was assaulted. She has used the word assaulted, and assault has been defined under section 351, punishable under section 354. But the charges here are under section 323, which are very distinct and separate. Secondly, she has not stated, she has not been specific who assaulted whom. Because initially there were five
The FIR is not an encyclopedia of events. And you are referring to factual aspects which will be dealt with by the trial court at the time of trial.
Agree. Now, second, I have included the statement.
You are under in an application under 482.
I agree. Now, one thing I would like to point out, that 5 witnesses have been examined. Their statement has been recorded under section 161 CRPC. Out of 5, 2 are independent witnesses. They have not stated a word against these petitioners.
Sir, don't you think you are again on factual aspects? Whether the case can be proved or not will be decided by the trial court and not in an application under 482. You have to show that there is no prima facie case.
I'm coming to that. Secondly, so far charges under section 447 is concerned, she has stated in her complaint that this petitioner criminally trespassed upon her land being plot number 160 part. The total size of the plot number 160 is 14.8 foot, and under their possession the land is only 6 foot, and those lands were acquired by them by forgery, by registering, by impersonation and forging a deed and registering it a registrar of the Calcutta. The land actually belongs.
You have filed a complaint in that regard?
Yes, she acquired the land of her own maternal uncle, and maternal uncle has filed criminal proceeding against them.
Well,
And
how it
came
is
before-
relevant?
And she came before this honorable court for seeking questioning of those proceedings, and this only last month.
So however she has acquired. Unless the proceedings are quashed, it remains. And that is again a factual aspect.
But
Even if she has acquired by forgery, she has acquired for the purpose of this complaint.
But only a part of 160 plot was belong to her. And there are a lot of litigations in.
So these are again factual aspects. This court cannot deal with it at this stage.
Let me come on the basis of the evidence on the record which the IO has gathered. Prima facie no case is made out, and if the trial is proceeded with, it will be simply an abuse of the process of the
Please show
court.
me the statements of the witnesses.
I've included the statement there.
Page
50.
22 onwards. Page 22.
I've also filed the translation.
It is in Nepali, my lord. Next page is.
Oh.
কি বলবো আমাকে বলতে হবে তখন বলবো
Page 23 is the translated version. Constitution of the complainant.
There is a long-standing dispute between the parties. They are
Between the
neighbors.
party.
Yes.
And she had laws against this petitioner, other criminal proceedings which have been quashed with this honorable court. And the proceedings which were brought by her own maternal uncle for misappropriating property, she came before this honorable court seeking questioning, which was declined with this court only in the last month, White CRR 270 and 271 of 24. Only in the last month.
So you say that similar complaints were lodged against you which have been quashed by this court?
Similar.
Where are those? Please show me the
I have
documents. Page, at page.
Lordship, may I submit only one thing? Since my learned friend is referring to one criminal revision that was heard by this honorable court, I pray, my lord, that the record be brought in. Because I have specific instructions from my client that she was not served even after the direction was given. And her presence is not reflected in the order sheet that your lordship will be going through. So let us find out from the record whether the second time service was done on the defect.
Where is the order sheet?
I filed the affidavit of service.
Where is the order sheet?
Let us find out what, either it was served or not.
You say that other complaints were lodged against you, right? Where are those complaints? Where are the order sheets?
Order sheets are here. One complaint was lodged against the mother-in-law of the petitioner number, page number 41. 41, annexure P6. This is the application, and
Not
with
only the application,
application, the
two
order
pages,
is annexed page 43. 43, page 43.
This is for forgery.
Forgery.
And this is against some other person. She is
Mother-in-law,
not the petitioner
the
here.
mother-in-law of this petitioner.
Yes, but she is not the petitioner in this matter, in this case.
She was the complainant. And the mother-in-law of this present petitioner, she had come under section 482.
This is a different case altogether, a 468, 471 case where there was no document, there was no proof. So it was
But
quashed.
between the same party.
Yes, but this is a different issue altogether.
Kindly come to the page 50. She has lodged another complaint against this very petitioner, which was requested by the Honorable, by learned Additional District Judge, Third Court, Sri Madan Mohan Mishra.
This is also forgery cheating, which has to be substantiated by documents. Here it is 427, 323, etc.
Agree.
This has nothing to do with these
Now,
cases,
one
right?
more thing, the maternal uncle of this de facto complainant, which has filed the case against her and who came under section 482, I have included the relevant
And this is against rejection of a 239 application. It was directed to be reconsidered.
Yes. And civil matters are also pending between both the parties, several civil litigations. And her own
How many witnesses are there?
only 5 witnesses.
So I'll grant, I'll pass a direction for expeditious disposal. Please face trials.
That will be simply vestige of
I do not really find,
Now, one.
because whatever
no,
you're
one-
mentioning are all factual aspects.
Now, one thing more, the petitioner number 2 and 3, they have been, one of them is residing in Mumbai and another is residing in Pune.
All the addresses are of Darjeeling. None of them are of Mumbai or Pune.
They are local address. It is their local address.
Yes, so their local address means they're residing in Darjeeling.
They used to, but now they are out of Darjeeling.
You have to amend your, you have to amend your application otherwise. Your, the address is of Darjeeling.
My submission is, your lordship, it will be simply abuse of the process of the court, wastage of the court of time.
Let me hear the opposite parties.
Lordship,
Yes.
Similar allegations were taken up in 2 applications before the learned magistrate, jurisdictional magistrate, and also before the learned session judge at Darjeeling. After the plea was done, they went before the learned magistrate for a discharge. That was dismissed.
It was not plea bargain, before plea.
Whatever. After plea, the court is hand tied. Your lordship knows that in a summons tribal case, once the plea is made, it has to be tried. This was carried to in a revision to the before the learned session judge. All these grounds were agitated, and the learned session judge was reasonable to dismiss the revision.
That's why they are before this court.
Now they have come to this court. Now, my lord, 323 is such an offense that can be even proved by oral evidence. But here we find a medical certificate has been seized. Now, my lord, how much the credence will be given to the medical certificate and how much weightage is to be given to the statement of the witnesses that is on record has to be decided by the learned magistrate who will try the case. The grounds that have been taken, first 4 grounds, my lord, that is I think that is a copy paste error. The very peculiar grounds have been taken, my lord. The cause of action is arisen within the jurisdiction of this honorable court. Lordship, internal page 11. Page 11. That there is no other alternative and efficacious remedy available to a petitioner than to file this application, and the relief spread for therein, if granted, will give your petitioner full and complete relief. These are the grounds.
These are technical.
No, my lord.
One more very
5,
important thing.
Mr. Agarwal, when you submitted, I was quiet.
Okay.
Now, lordship, from 5-4 onwards, as your lordship has already pointed out, and need not delve in it, though I was carrying a judgment of the honorable court. FIR need not be the encyclopedia of all events. My lord, from the record, whatever materials are before us today, your lordship is perusing. One thing is clear, there was a scuffle. And the fencing was broken because the wire and fences have been seized. And there is a medical certificate to the effect that one of the defective complainant had been medically examined. So, mischief and hurt ingredients are there. Lordship very well know that 482 cannot be just for a drop of the hat cannot be invoked. If even these were absent, 482 could have been activated. But at least, prima facie glance, we find that 323 and 427 is there. Now, we do not know, lordship, today standing here, that during the course of trial, the learned magistrate may find some more material coming forth from the witnesses of the statement on dock. Some more sections may come into play. The magistrate learned magistrate have all the power under the sun to add, alter, change the charges. As your lordship rightly pointed out, it is a preemptive stage to go and say the trial is fruitless. And if the trial is so fruitless, the accused should go with the pumped up chest and face the trial and get an acquittal.
That's all.
So, my lord, I humbly pray that this petition be dismissed.
Yes, state.
My lord, charge sheet submitted after completion of investigation, 5 witnesses are there, my lord, including the.
Any injury report?
No, it should change. In charge sheet is 23.
Produce medical report. She produced their medical report and the photocopy of the medical report.
I have no case diary right now, but the 407 copies are there.
Let me just submit. No, that
He has come not completed, sir. Please wait.
But five witnesses, given just statements, including the defense complaint, there is I was fine, my lord. And when we oppose, they pushed my father and me on the ground. This is the ground of the 323. That's charge sheet, sir.
Lordship, regarding your lordship's query regarding medical documents, if lordship kindly takes page 20, the charge sheet, the IO has clearly said the medical certificate is there and it is in the case diary.
I'd like to.
323 medical document is actually not required, but then when there is a reflection in the charge sheet, that's why I was inquiring.
I'd like to submit your lordship that no doctor has been cited as a witness in. charge
Yes,
sheet.
there's no doctor.
And they were not referred to.
323, sir, you don't need to have a doctor.
But they were not referred to the hospital at the time of the lodging of the complaint.
A slap also may invoke 323, you are aware.
I agree, but they were not referred to the, when there was specific allegations that she has been assaulted or pushed to the ground, they should have been referred to the hospital. by the police.
Not all, that's why it's 323 and not 324, 5 or 6.
And secondly, I would take your lordship attention to the page 40 seizure list.
What document?
The fencing wire and plunger were seized from the possession of the de facto complainant.
Naturally, they
No.
did not carry it.
No, it should have been seized from the spot. But it was seized from the possession of the de facto complainant. And two witnesses have been cited in seizure list. One is Ali Akhtar. He has since expired. I filed the death certificate.
That has to give a ground.
Number two is Taran Kumar Sharma, who happens to be the maternal uncle of the de facto complainant and who has initiated criminal proceedings against the de
Sir,
facto
I
complainant.
agree to all that you are saying, but these are all factual aspects. Let the trial court deal with it. I'll request the trial court to dispose of the matter as early as possible.
Only five witnesses.
Only five witnesses.
Only five.
And a very small case, a very short matter, let it be considered as early as possible. Affidavit of service. Heard learned counsels for the parties. Paragraph, the petitioners seek quashing of GR case number 18 of 2022, pending before the learned Chief Judicial Magistrate, Darjeeling, on the ground that they have been falsely implicated and the FIR does not make out any offense as alleged. They are neighbors, right?
They are neighbors.
The parties are, the parties are neighbors. And there are long-standing disputes
I'm kindly permitted.
between them.
The father of this de facto complainant, he is a retired PSP of police. And she is holding some official post in the Association of the Retired Police Officers.
Is it part of your application?
I have stated my application. And secondly, this de facto complainant, she was married, she used to reside in Philippines. She used to reside in Philippines along with her two daughters and husband. She left her husband, she came back to India, she initiated various processes, 498, 125, TV.
That is between her and her husband, sir.
No, thereafter, she started raising boundary wall, boundary dispute with, along with all the other neighbors. They all
That
along
doesn't really mean that you can go and break the wall, demolish the wall.
I haven't.
That will be dealt with by the trial court. It is apparent that there are disputes between the parties, which may have resulted in these. I'm not commenting on that, but then let the trial court decide.
Then, sir, the two sons, as I stated, who have been residing in Pune and Mumbai, they be asked to exempted from appearing day to day.
So you have 317, you have 205.
Learned court.
You
may
can
take-
file relevant applications.
Learned court may take below some other view, they have to be present.
Long-standing PP of the Sessions Court, he knows this very well.
You will. There are long-standing disputes between them. No, let us not pressurize the magistrate. There are other matters also. Paragraph. Learned counsels for the private opposite party and the state submit that charge sheet has been submitted. Stop. It appears from the statement of the witnesses recorded under section 161 of the Code of Criminal Procedure that the allegation is substantiated. So the FIR deals with the alleged incident and is sufficient to proceed with the matter. Stop. Charge sheet has been submitted to the chief. Fine. For learned counsels, it appears that charge sheet has been submitted against the petitioners under section 447, 427, 323, 506, 34 of the Indian Penal Code. Stop. Learned counsel for the petitioners has submitted that the complaint has been lodged on false and frivolous grounds due to prior enmity between the parties. Stop. Several factual aspects have been raised by learned counsel for quashing of the proceedings, which, in my considered view, cannot be dealt with by this court in exercising jurisdiction under section 482 of the Code of Criminal Procedure. Stop. Such factual aspects shall be dealt with by the learned trial court during trial upon recording state evidence of witnesses. Paragraph. Since the FIR deals with allegations which make out a prima facie case, as alleged, the matter needs to be dealt with on merits by the learned trial court. Stop. This is not a case which can be disposed of, which can be quashed in limine under section 482 of the code. Paragraph. Learned counsels for the parties. Little softly, please. Learned counsels for the parties submit. No, that's it. It appears from the charge sheet that 7 witnesses, whatever, I mean, there are 7 witnesses. that seven witnesses are cited in the charge sheet. Paragraph, in view of the above, comma, the learned trial court is directed to take the proceeding to its logical conclusion within 1 year from the next date of hearing fixed before him, comma, without granting any unnecessary adjournment to either of the parties, comma, in accordance with law. CR are dismissed, urgent certified, etc. Next. Service not effected. Since service upon the opposite parties is not complete, comma, the matter be placed before the since service upon the private opposite party is not complete, comma, the matter be placed before the next available circuit bench. Friday, I cannot fix. There are a lot of matters on Friday. I cannot fix. Next.
37 Millard, I beg to appear for the petitioner. Millard, this is Millard. Millard, this is for quashing of Millard charge sheet under the Provident Funds Act. I mean, the ground which we have taken, Millard, has already been decided by a coordinate bench in very clear terms, subject to your lordship's consideration of the same. Millard, the only point is whether the charge sheet submitted is in contravention of 14A of the Act. That is, without implementing the company, whether this proceeding can go on. And Millard, this honorable court.
Have you served the state?
The state was since Mr. Mahasha is the complainant for the Provident Fund authorities. Millard.
No, there was a direction for please serve the state and county.
Right, Millard.
These are the judgments.
These are the judgments. Two
Please serve the
judgments.
state and county.
Millard, on Monday, Millard, is subject to lordship's
Come back on Monday, let me give it a try.
Monday.
Monday. Since service upon the state is not complete, comma, let the matter stand over till 23rd December 20.
Millard can take it up tomorrow also, Millard, if you can serve today. Oh, election. That's it. Monday, Millard. I'm sorry.
Next. Which matter? Second application. Anyone appearing?
The earlier matter, Millard, state is there.
You have not served.
Millard, it was served. My service, Mr. Chakraborty is.
Affidavit of service is also not there. Mr. Chakraborty, have you received a copy in the earlier matter?
I need to copy.
You're ready? You're ready? Can we deal with it? The private opposite party has left.
No, Millard.
No, he's there. He's there. 38, please wait, I'll read.
So Millard, today, Millard, I am only Millard on a prima facie because in the motion stage service was directed. So Millard, I am only on the prima facie view of this court, Millard, whether this Millard revision, Millard, is Millard to be admitted or not. Because earlier.
Since you have served already and they are there.
Yes.
Deal with the divisional application.
No, that doesn't matter. Yes, definitely. Now, Millard, kindly, Millard, takes the charge sheet. Millard, it's very clear, Millard, the company is not a party. And the only question to be dealt with is whether without implementing the company, whether this charge sheet is prima facie, Millard, bad in law in view of section 14A of the Act.
Please give me the Act 14A. Only the petitioner is the accused here.
Only the petitioner
The
is the.
provision, please. This is a 406-409 charge sheet.
Yes, yes, yes. My lord, kindly sees the judgment. My lord, this honorable court, my lord, has held that, my lord, only 406-409, my lord, cannot even go together. In a case where a default of, my lord, 406, default of Provident Fund is alleged. My lord, in this particular case, my lord, just to, my lord, demonstrate my bona fide, the amount which was impugned or, my lord, alleged to have not been paid in the FIR has been deposited long back. So that bona fide, my lord, is there prima facie. Now, my lord, para 19 of the first judgment, my lord, which I have handed up to your lordship, my lord, Rajkumar Jain, CRR 790.
Rajkumar Jain.
Yes.
Para?
90,
90?
90, yes. The complainant, without taking recourse to the provision under section 14B of the EPF Act, opted to prosecute under sections 406, 409 of the Indian Penal Code, which is exactly the case in hand. Now, my lord, 20 discusses the provision. 21, 22, 23, my lord, discusses the observations of the Supreme Court on this, Honorable Supreme Court on this. Therefore, thereafter, my lord would find, my lord, 27 is, my lord, the final finding of the court. Thus, the prosecution initiated against the director of the company in his official capacity without airing the company itself as an accused cannot continue, as no offense under section 406, 409 IPC can be said to have been committed by the director in his official capacity without the company being made an accused with the liability of the offense. It is straight law that vicarious liability is unknown to criminal jurisprudence unless specifically provided in the statute itself. As the penal code does not provide for such provision, the director petitioner cannot be held responsible for any act of the company who is the employer and is liable for depositing the employee's share of Provident Fund before the Provident Fund Authority without making the company also an accused in the case. The revisional application is allowed, proceeding has been quashed.
Yes, the law is very clear.
I mean, same view has been echoed subsequently, and on this point, my lord, I can cite at least 7, 8 orders, judgments. My lord, law is very consistent now.
Let me hear. This is a very short issue to be decided. Yes. Yes.
For my, was stated by the petitioner at the time of the filing anticipatory bail, that there is an order, and as per the pursuance of that order, the conditional deposited right. That can be found in the their order of the honorable court, the bail order.
Page 20.
Page 20. Page 20. 11 lakhs 65,848.
The petitioner says he has deposited this amount.
Yes,
Yes,
they
it has been
deposited
deposited.
at the time when they were preferred for anticipatory bail, and therefore he paid. Prior that he is not.
This is a different issue altogether. We are on a preliminary issue. Have you seen these judgments?
Lordship, this is.
So very clear.
Lordship, but whatever the crime is concerned, that is
Irrelevant. Irrelevant. 14A has not been complied with. It doesn't, it's not maintainable.
Lordship, so far, my submission is concerned with the Provident Fund Authority.
I'll request you to take instructions because I have to allow this revisional application and quash the proceeding. Not everything on Monday. Tuesdays are last working day.
Vote on Thursday.
Election is tomorrow.
Friday or Monday.
Mr. Mahasaya has appeared, my lord, at least 10 proceedings. I know where I am for the petitioner. Mr. Mahasaya is very clear on the law. Track করে লাভ নেই, কেন করবে বলো?
Two options. One is dismissal. Second is you can withdraw the complaint.
They can take recourse under section 14B of the Act. No one stopped them.
That case. But thing is then on behalf of the state, my lord, there was a temporary deportation.
No role to play here, actually. State has been made a party, you know, but what does the state have to say here?
No, look,
This
has become
authority to decide. The amount has been admittedly deposited. that really does not absolve the petitioner from the allegations, right? The offense still remains, fact. But then if it is beyond the law, beyond the statutory provisions, 14A has not been complied with. So you have two options, sir. One is accept a defeat. Second is you can withdraw the complaint.
The judgment and Mr. Ghosh is also always hammering on that point, Lordship.
No question of Mr. Ghosh hammering. This is the law.
No,
The law hammers on the point. That's the difficulty.
This has become a very technical exercise of statutory power so far as PF is concerned. The moment they receive a complaint, 406, 409. But the Act itself provides a recourse. Until and unless you go by it, merely invoking this, Millard, is only.
14B has to be invoked.
Right.
14A complied with, and the company has to be made a part.
Made a part.
Yes. So I can give you a date to take instructions whether you want to withdraw the complaint or allow a dismissal. These are the options left.
Withdraw is not possible for this again going for a withdrawal. My lord is
Because once it is dismissed, you will face difficulties in filing another application. Let me be very candid. Yes, I'll pass necessary orders.
Grateful, Millard. Millard, kindly.
I'll reserve it. Let me deal with other matters.
Yes,
I'll
yes,
pass
yes. No,
orders.
yes, yes. No detail.
My petition, my kindly be on that point.
Vehement objections be there.
Vehement objection.
Objection in the
Third learned counsels for the parties. Judgment reserved. It will be need another. PNA. Better deal. Later, be. Mr. Ghosh, I'll retain the book for some time.
No, no difficulty. I am for this too. That
Petitioner?
matter, my lord. The DNA test, second application.
No one appearing. Passed over, let me see. Second call, I'll consider. Pass orders.
I am appearing for the petition. I have come before your lordship for a quashing of a proceeding under section 365, 376, 417 of the Indian Penal Code. This is only for the petitioners, lordship. Lordship, in this case, what has happened? The daughter of the opposite party number 2, she had a love affair with one Ruksan Alam, and they fled away voluntarily, and they thereafter the de facto complainant lodged this FIR, lordship. Subsequently, they got married, and these petitioners, they are the distant relatives of this Ruksan Alam. They have no way involved in this case, lordship, but they are implicated in this case. They are they
Charge
reside.
sheet submitted.
Lordship, charge sheet submitted.
When is the next date?
State.
You've not annexed all the order sheets actually. Oh, 1st March 25.
Yes.
Serve and come back.
So in the meantime, let there be a stay.
Stay for what? Charge sheet submitted, you're on bail, 1st March is the next date. So nothing will happen in between, right?
Yes.
You don't need a stay. Serve and come back, next circuit.
Okay.
Decided on a compromise, please speak to your clients. Since they are married and they are settled,
yes,
why continue with the case like this? Can be settled on a compromise.
Wait a fast time.
The petitioners are distant relatives of, who is the principal accused? His name is?
Ruksan Alam, lordship.
Of the principal accused. You've not annexed the charge sheet.
I have the charge sheet.
Rukshan Alam, RUKSHAN,
Lordship.
of the principal accused Rukshan Alam, who had a love relationship with the daughter of the de facto complainant, slash private opposite party, and fled away with her.
Yes.
And fled away with her. Stop. They have subsequently married and are leading a happy marital life.
So marriage certificate is page 90. Marriage certificate.
The petitioners seek quashing of GR case number 3943 of 2023, pending before the learned Additional District and Sessions Judge, Third Court, Jalpaiguri, primarily on the said ground.
So who are the petitioners? Because
Others
Rukshan
are
Alam
also there.
Rukshan Alam
The
has
petitioners seek quashing, yes. I'm only giving a direction for service, that's. The petitioners are directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the agenda date. Paragraph, the matter be placed before the next available circuit court. Next. 41.
40 minute, I am appearing for the petitioner.
I am for the state.
Last matter was what?
Last matter was 39.
39.
In this matter, my lord, I'm praying for quashing of a case registered against me, being Pradhan Nagar PS
Have you
case.
served?
Yes, my lord.
You're appearing for?
I am for the state.
What about the second opposite party?
My lord, affidavit of service is here, my lord, we have served. Well, this case pertains a very basic question of law that without the compliance of section 195 of the Criminal Procedure Code, if a case of section 188 of the Penal Code can be charge sheeted or cognizance can be taken into that. Now, my lord, it's a settled principle of law that it cannot be. And the added sections, such as in this matter, it's 354, if they are done in the same transaction, my lord, that also on that also, my lord, cognizance cannot be taken, shall not be taken, my lord.
Charge sheet submitted.
My lord, charge sheet has been submitted. Now, my lord, the crux of the allegation, if I may apprise your lordship, is that the petitioners are the doctors and the managing staffs of a hospital. Now, my lord, this complainant, along with some advocates and of NGO, my lord, the complainant's father was admitted before the hospital. Thereafter, he was admitted for 5 to 6 days straight. At the time of bill, they submitted Shastro Sathi card. Now, my lord, Shastro Sathi card for internal reasons they could not accept at the time of billing. It had to be submitted at the first instance. Anyway, now, my lord, they have filed this case under section 188 that by not accepting that Shastro Sathi card, we have violated and committed an offense under section 188. Now, my lord, if I may apprise your lordship with section 188 of the Penal Code for one instance, if your lordship. May I read, my lord?
Give me a minute. Yes.
My lord, it is disobedience to order duty promulgated by public servant. Whoever, knowing that by an order promulgated by a public servant lawfully empowered to promulgate such order, he is directed to abstain from a certain act or to take certain order with certain property in his possession or under his management, disobeys such direction shall, if such disobedience causes or tends to cause obstruction, annoyance, or injury, or risk of obstruction, annoyance, of injury to any person lawfully employed, be punished with simple imprisonment, for which may be extended to 1 month, and thereafter, my lord, the second
It's not applicable.
well, not applicable, my lord. Now, my lord, kindly comes to section 195 of the Criminal Procedure Code, my lord.
CRPC. Yes.
My lord, this is prosecution for contempt of lawful authority of public servants for offences against public justice and for offences relating to documents given in evidence. Now, my lord, I am concerned with subsection 1 only. No court shall take cognizance. 1A 1 is that on any offence punishable under section 172 to 188, both inclusive of the Penal Code 1860, 2, if any abatement or attempt to commit such offence, or 3, if of any criminal conspiracy to commit such offence, except on the complaint in writing of the public servant concerned or of some other public servant to whom he is administratively subordinate. Now, my lord,
Here it is by the patient.
yes, my lord, it had to be registered by the chief medical officer of health or by his written requisition by the deputy chief medical officer of health of that district, or if it is a block, then BMOH. Now, my lord, this has not been complied. Now, my lord, if your lordship would kindly consider, it's a
What about 354?
yes, my lord. That's what I. How can I copy? Sir, my lord, if your lordship would kindly consider the. Sir, I'll share. This is a judgment by this honorable court passed by my lord Justice Ajay Kumar Mukherjee on 10th of May 2023. This dealt with this same problem, my lord. This 188 without compliance of 195. Now, my lord, the connected sections, if it is 354 or 441, 447, anything. Now, my lord, if they are done at the same instance, at the same transaction, then, my lord, they also are liable to be not to be taken cognizance of. 190 cannot be applied on that if that is done in the same transaction, my lord. In this matter, if your lordship goes to the FIR, your lordship will find that the hospital staff denied accepting the Shastro Shati card, and thereafter some.
Where does the law say that if it is
Yes.
the same transaction?
Yes, my lord. I'll apprise, my lord. I'll apprise, my lord. My lord, kindly comes to internal page number 7, my lord.
Yes.
My lord, last paragraph. Now, in order to deal with the question as to whether clubbing of offences under section 447/34 or 506 of 34 IPC with the section 188 of IPC would be permissible under law when it is not in dispute that for the offence alleged under section 188 of the code, the provision of section 195 of the code has not been complied with, and when the allegation of section 447 and section 506/34 of the IPC has been alleged in the course of same transaction, my lord. In this context, the apex court, in a judgment of Durgacharan Nayak and others versus State of Orissa, my lord, I have that, if your lordship would see, reported in AIR 1966 SC 1775, was pleased to hold in paragraph number 8 as follows. We have expressed the view that section 195 of the Criminal Procedure Code does not bar the trial of an accused person for a distinct offence disclosed by the same or slightly different set of facts and which is not included within the ambit of the section, but we must point out that the provisions of section 195 cannot be evaded by resorting to devices or camouflage.
I've seen this.
My lord, may I submit that judgment also? This Durgacharan Nayak, if your lordship.
Lordship.
My lord, my lord, if your lordship would kindly seize the petition, my lord, page number 19 onwards, Annexure C. My lord, kindly seize 19, 20, 21.
The statements.
Yes, my lord. On the stone upon which they are proposing to proceed with the trial, my lord, kindly seize if 354 is there or not. Well, if this is not the camouflage, my lord, I ask this question to myself, my lord, what is? My lord,
Let me hear
my
the
lord,
state. Yes.
Lordship, first of all,
Point of law.
only one point of law. First of all, the section 354, that is the outrage of a modesty, cannot be a part of a same transaction because the section with the judgment The judge, yes, no, I have not seen this. The judgment of the single coordinate bench, which was placed before your lordship, that relates to section 447. That is a criminal trespass. And suppose an order has been promulgated that that religious rally will not go through X street, X name street. And if that religious rally go there in that street, that is the violation of section 188, and under section 195, by complying, the public servant can lodge the FIR. But denying Shastro Sati card is obviously the disobedience of the order of the state government. No doubt. But the complaint has not. Who will lodge the complaint? Who will lodge the complaint? That is the point. But outraging the modesty of a nurse.
It is in the process. Please see the complaint. It is in the process. It is not a separate outraging of modesty. They refused to accept and were pushed. That's the 354.
And lordship, moreover, case diary is very much required, because whether there is any medical report or not.
Not necessary at all. It is, case diary will be necessary only if this is maintainable, not before that.
Lordship,
So please make your submission on the maintainability first.
yes, maintainability, because section 354 is there. Lordship knows better than me that the section 482 will be invoked only when there is a prima facie, the case does not invoke any if I does not invoke any prima facie case, and there is a gross miscarriage of justice if the case carries on. But here, lordship, there is an outrage of allegation of outrage of modesty.
Maintainability, please, maintainability ground. If you want to see this judgment and come back tomorrow, you can do that.
Then lordship may kind enough to fix it on Monday, because there are two different thoughts. Different thoughts.
Monday, I'll.
Tomorrow, lordship, tomorrow, Bar Association election is there.
Come back on Friday.
Yes, lordship, Friday.
Please consider this judgment and come back.
Yes.
I do not find anything.
What is my senior?
I do not find any ground to take a different view.
Lordship, let me peruse the judgment, and if there are different thoughts, I'll try to appreciate this, your lordship.
The very clear averment is Shastri refused korlo ebong dhakka diye ber kore dilo. So it is in the same transaction.
Same transaction.
The same sequence of events.
Lordship, let's see if I can appreciate.
The judgment is absolutely a pat on the point.
Let me try to appreciate the court on another thought, if possible.
Third learned counsel for the affidavit of service. None appears for the private opposite party despite service. Paragraph, third learned counsel for the petitioners. Paragraph, learned counsel for the state seeks accommodation. Paragraph, let the matter appear under the same heading on 20th December. Next. Who is appearing? You filed the documents, right? Yes. So you have no objection if this is quashed? No objection? You are for the state? Yes. Will not absolve the liability, yes.
If there are any other ground Yes, I have seen there ago. So if those grounds are paid, in aside the payment, there are technical ground that they have made the if the decision will be taken by the okay. Earlier one, the economic side.
No compliance of 195, right? That's your next ground. No compliance of 195.
The amount has not been misappropriated. There's no application that amount has been so some other purposes, the company has used to some other. It's not even, even for the company, the application not have been. And on the very same day, the FIR was registered, a notice was issued on the same day, FIR was also lodged simultaneously under the CFR. FIR lodged at the same time, the CF notice of the CFR also was given at the same time. They could have proceeded with that, but immediately had lodged an FIR. And there's a I don't know the condition of it regarding the.
Let this, yes, anything to add?
Putting the of this case, it's to support the case, but
No, you don't need to support exactly. But then let me pass it on.
Payment part, particular that we have, they have already made the offense and never was. So payment does not dilute here.
Dilutes, doesn't absolve. It dilutes, obvious, definitely dilutes.
Hopefully the principal has. But if there has been a. Over the payment aspect, this consideration should come into the picture.
Well, let me not go into that. Let me stick to 14B, 14A and yes. In any event, you require a quashing, isn't it? Third learned counsels for the parties. Paragraph. The petitioners who are the manager and director of Messrs. Sourenee, Sourene, Sourene, N for Nagpur, Sourenee Tea Estate, respectively, seek quashing of GR case number 55 of 2022, pending before the learned Additional Chief Judicial Magistrate, Kurseong, Darjeeling. Paragraph, learned counsel for the petitioners submits that where is the complaint? Certified copy. Yes. Charge sheet submitted. That charge sheet has been submitted against the petitioners under section 406/409 of the Indian Penal Code. Without complying with the provisions laid down under section 14(a)/14(b) of the Employees SL for apostrophe Provident Funds and Miscellaneous Provisions Act. Stop. The entire due amount of the employee's contribution has been admittedly deposited by the petitioners. Stop. Deposited by the company, right? Deposited by the company. Paragraph, learned counsel for the petitioners has placed reliance on judgments of coordinate benches of this court in support of her contention. Paragraph. Learned counsel for the Provident Fund Authority admits payment of the due amount by the company after lodging of the FIR. Learned counsels for the opposite parties oppose the prayer. Counsels oppose the prayer. Let me stick to that, restrict myself to that paragraph. It is not in dispute that the entire due amount has been deposited by the company after lodging of the FIR, right? Paragraph. It appears that the FIR has been lodged against the manager and the director of the company without including the company itself. Paragraph. It is pertinent to reproduce section 14(A) and 14(B) of the Employees Provident Fund and Miscellaneous Provisions Act. Stop. 14(A), 14(B) টা আসবে reflected. আমি দিয়ে দিচ্ছি আপনাকে। Paragraph. Therefore, it is crystal clear that a prosecution initiated against the manager and director of the company without roping in the company itself director of the company under section 406/409 of the Indian Penal Code without roping in the company itself is bad in law and therefore cannot be allowed to continue. Stop. It is right law that vicarious liability is unknown to criminal jurisprudence unless specifically provided for in the statute. Paragraph. Since the company itself has not been arraigned as an accused in the present FIR, the petitioners, being the manager and the director of the company, cannot be held liable for the offense in their individual capacity, more so since they have been included in their official capacity. Paragraph in view of the above, this court is inclined to hold that the proceeding being GR case number 55 of 2022, pending before the learned additional chief judicial magistrate, Carsion, is liable to be quashed. Paragraph, the revisional application being CRR such and such is allowed. The proceeding being GR case number 55 of 2022, pending before the learned additional chief judicial magistrate, Carsion, be quashed. Liable to be quashed. এখানে be quashed করুন, be quashed. The petitioners are on bail. Oh, warrant is issued. Warrant has been stayed. Proceeding যেটা বললাম, including the warrant of arrest issued therein. If the proceeding is quashed, the entire thing is quashed. Urgency factor. No, including the warrant of arrest. I'll deal with that when I reach 42. Oh, next matter. Oh, yes. So, the
General Board of Attorney edits at the last page of the petition, so that only one petition, that is petition number 2, and even the Provident petition number 1 have not been.
You have it with you? So there should be two separate. Yes, prior to that, there is another power of attorney. Another document. Shakil Mullah.
Shakil Mullah is the consulted attorney and executive one.
No, this is by Anubhav Agarwal. There are two documents here, two separate documents.
There has not been
That's the only difference that you say in this. You have not asked for quashing? Page number 22 and 23 are the prayers. Come to the prayers, sir. Come to the prayers, please. Yes. Entire prayer.
Make the submission of the state. For team A and C is not applicable as because the company has made a party accused and so only for regarding the payment.
Company at all. The company is Martigara Realtors. No, Martigada, yeah, it is. Yes, my lords, that's the company's name. My lords, you come to the chart sheet at page number 31, my lords. Tea Garden name is not the company. Tea Garden company is not in the name of the tea.
The company
The
is
company
Messrs.
is,
Mati Garden
I have
Welfare
written it in
Private
the,
Limited.
that's specifically stated. Yes, it is stated in my petition.
Maybe subsequently it has been.
My lords, chart sheet has in my lords. My lords, you come to the chart sheet, page number 31, my lords. Page number 31 is the chart sheet, my lords. My lords will look at the names of the accused persons. Now, at para 10. Column 11.
Column 11.
Huh. The company has not been made.
Where is the company? Accused persons? The chart sheet?
Our problem.
Take.
Column 11. Column 11. Kindly see.
It's only
Sir, we
Anubhav
have-
and, I mean, these two petitions.
Yes, my lords.
Column
Sir,
11 below. How can we
Take
know
the-
what is?
my lords, even I have a Xerox copy very similar to this. What do I do, my lords? I'll just.
How can we know?
My lord, sir has. Sir, do you have a CD?
No.
Please bring the CD in that.
Lordship,
Friday.
there was a-
And my lord's payment has also been done. My lords, maybe.
No, that's one aspect.
Yes, my
Yes,
lord.
one. 41 A and C that are the decide now. तेरा नहीं है, उस दिन वीडियो पूरा नहीं होगी।
Yes, column 10.
He's right.
Only these two petitioners, not the company.
And even in the FIR, my lords, charge sheet also. My lord, nothing remains.
This
My lord's
goes
case-
to another advocate who is in post number 3.
My lord, to give a short waiver, that advocate may come.
Only point him. So
Passed over.
Pass over.
Passed over.
My lord, at
Come
2
back at 2
2
p.m.
p.m. Grateful, my lords.
I'm only submitting what I have been instructed.
Because it's a similar order,
Lordship,
so I would like to dispose it of.
My lord, this is a better case. My lord, no notice has been ever issued under the PF Act. Grateful, my lords.
2
Yes,
p.m.
grateful, my lords.
When I call the passed over matters, I'll call this matter
Lordship,
also. Yes, next.
Lordship, praying for not today.
Not today.
Not today.
Not today. These matters were appearing yesterday also, isn't it? Everywhere not today will not be allowed, madam.
Lordship,
This
I
is the
am not
last
the
date.
opposite party, Lordship.
She's asking for a not today, only for today. Tomorrow I'll send it to the other.
Sure,
section.
Lordship, kindly keep it on Monday because I am traveling through another city for 2 days.
Which one? 44?
44.
Learned counsel for 44. Learned counsel for the petitioner seeks accommodation. Petitioner. Let the matter appear under the same heading on 23rd December. Next.
My lord, I'm for the opposite party to it.
Yes.
Petition.
Yes.
My lord, I'm opposing the application because my lord, there is a prima facie case under 409. Which cannot be compounded.
Milord, let me submit. Yes, you'll get the opportunity.
Yes.
Now,
Why is there a question of compounding?
My lord, they have.
Milord,
Let them
ma'am,
submit, my lord, alone.
Milord, the petitioner was an employee of a hospital, Paramount Hospital. After 23 years of his service, he took voluntary retirement due to his old age. And immediately after he retired, he voluntarily gave retirement on 14/11/22. Immediately after his retirement, he asked for the gratuity refund, demand of gratuity from the hospital authority. But when it was declined, he made an application before the controller gratuity authority for disbursement to the amount. And he made an application on 30th of January 23. Notice was issued on 23 March 23, 23rd March 23. And immediately thereafter, as a counterblast, the hospital authority lodged a complaint to the Siliguri police station alleging misappropriation of some fund against him. After retirement, Milord, this is pertinent because during his whole service period, there was no allegation at all. But when he demanded the gratuity, when it was lodged before the controlling officer, Thereafter, as a counterblast, he lodged a complaint, the hospital authority complaint, lodged a complaint to the police station for misappropriation of fund. Thereafter, after a long course of negotiation and everything, a settlement was arrived at, and an MOU was agreed to and executed on 1/9/23, page 32, my lord, page 32. I beg to draw lots of kind attention of about in 23 page number 23. This is page number 32. I'm sorry.
Yes,
I beg
32.
page number 32. Memorandum of understanding between both the parties. And in the memorandum of understanding, your lordship will please to find para 1, terms and conditions. Para 2, that the second party agrees and undertakes to withdraw the complaint at the earliest, being case number this pending before the office of the Additional Labour Commissioner, North Bengal Zone, Government of West Bengal, filed by the second party against the first party, alleging non-payment of the gratuity amount by the first party. So, and it was accordingly withdrawn. Now, I come to page para 8, that the dispute between the parties has been amicably settled due to the compassion and sympathy shown by the first party towards the family of the second party, and it has been mutually decided that the first party shall render all necessary support and cooperation to withdraw the allegations leveled against the second party number 1 and 2, more specifically being Siliguri PS case number this penal code. Next, 1890, that para 9, that the first party, apart from filing an affidavit through its authorized representative, authorized signatory, stating that they have no objections if the second party, namely Indra Chand Agarwal, be released on bail before the court and additional Chief Judicial Magistrate Siliguri in connection with this case, 420 Indian Penal Code. And the first party shall also do the needful and get the above caption case withdrawn against the second party number 1 and 2, namely Indra Chand Agarwal and his wife, Srimati Bina Agarwal, either by way of acquittal, discharge, final report, or render all necessary assistance in getting the same withdrawn from the competent court of law, as the same has been compromised and between the parties. Next, and accordingly on the same day, they file an affidavit before the police station and before the court. Internal page 4 of the certified copy. The order passed by learned ACJM, Additional Chief Judicial Magistrate Siliguri, page 4 of the certified copies. Date 1/9/23, on the same day, they filed an affidavit.
Give me a minute, please. Order dated 1/9/23, yes.
1/9. Had the learned advocate for the accused, learned APP, learned advocate for the accused submitted.
Yes, I've seen this.
Yes, submitted that the allegation basically that, and the one Ashish Kumar Giluka is present today and has stated in affidavit that the matter in dispute has been amicably settled. Learned advocate APP submitted the accused was an employee, and if the allegations are perused, it does appear there is a big doubt as to this. The de facto complaint is stated on top that the matter in dispute has been amicably settled. No objection has been raised to his identification. Considering all such, it does appear that the accused should be granted the liberty of bail. Learned advocate submitted that no application was preferred pending before higher forum, hence the accused person may be enlarged on bail. This was the order. The affidavit was sworn in, the amicable settlement was agreed to, and it was submitted before both the parties. Thereafter, I don't know what is the reason, charge sheet was submitted. Well, there are two things. Your lordship will appreciate that I won't go to the factual aspect. I will go only 3 points. There is no necessity of prolonging the litigation, for continuing with the proceedings, and ultimately it will end in acquittal. So, for the ends of justice, the charge sheet submitted by the investigating officer is required to be quashed, because there is no necessity. When the complainant himself says before the court by filing an affidavit that yes, agreement was executed and we would like to proceed with the case.
Let me hear the opposite parties.
I want two things. The decisions of the Honorable Supreme Court, I beg to submit. The one thing by Chandrachud, Justice Chandrachud, this is, my lord, the Kapil Agarwal's case, yes, the page 6, para 6.1. Lord, 6.1. As observed and held by this court, this is the division bench judgment of the
Yes.
Supreme Court.
Yes.
So as observed and held by this court in catena of decisions, inherent jurisdiction under section 482 Code of Criminal Procedure and or under section 226 of the Constitution is designed to achieve salutary purpose that the criminal proceedings ought not to.
This is on 482. This is settled law.
Yes, it is settled law. And another decision of Justice Bella Trivedi, this is a very recent 23 judgment. This is para 13. Para 13. Para 13 says, it is unnecessary for the ends of justice. There is no necessity of prolonging the litigation and continuing with the proceedings. Absolute miscarriage of justice. This is para 13. It cannot
This
be
is
then
again the
said that
same.
the High Court have power to qualify and that it has to be the criminal proceedings to be
There is no
qualified by the
doubt
High
with
Court and
regard
section
to this.
42.
This is settled law. This is
Settled law,
no
that's
doubt.
settled law.
Yes.
I agree.
That's
So-
all? That's all your submission? Yes, the opposite parties.
I know they have pointed out a memorandum of the case is an embezzlement by a person in. I know once that comes into play.
It's not under 409, sir. It's under 408. So 409 is dropped. Forget that, sir. After the compromise?
No, my lord, the compromise is not even effective, my lord. It is time, they have read the first part. They have embezzled a huge amount of funds, which they were supposed to.
Please come to the compromise.
My
Let
lord,
me see.
kindly take page number 36. My lord, there was. My lord, this agreement per se is null and void. Because, my lord, law is above the agreement between the parties. In case of not comfortable offense.
This is not a non-compatible offense, sir.
That is a charge.
It is only when your Naraji is allowed that you can say, and a final, and a further charge sheet is submitted on the 409, that you can say that it's non-compatible. Not at this stage. Not at this stage.
Subject agreement which they have referred. My lord, it is not been, and they have to show they have fulfilled the whatever they have given. Can you see this para number, page number 36?
Yes.
That there was two deposits, which is 25 lakh, that was embezzled. Out of which 20 lakh were to be paid. They have not paid that. Then they were to deposit all the private, the company's documents, the SIM cards, so that this is not given out. They have not surrendered that. They have not even abided by the condition. Now, my lord, our no objection was to be paid. Because on sympathetic ground, he was an employee, he said he will, whatever wrong he has done, he will give. On that ground, that bail was not objected. But my lord, if these conditions are not fulfilled, what is the effect of this condition? My lord, if once that application is heard by the landed court, because my lord, he charged it. And for investigation, is subject matter of that.
One question to learned counsel for the petitioner. Have you paid this amount of rupees 1,50,000?
Yes, yes.
Where is the document?
That they have admitted it, they have received it.
25 lakhs, out of which 20 lakhs was adjusted with the gratuity amount.
And after that, nothing else.
And the blank check is there, the check is there.
My lord, only amounting to rupees 9.
This
Another
is.
Rupees 1,50,000 was to be given by check.
And
Where is,
the SIM cards and everything were there, it is in the order sheet. It is in the order
where
sheet.
is your document showing that you have paid this amount and you have complied with this?
Page 41. The amount transferred in his account, in the account to the respondent from the son Vinit Agarwal. The entire amount, this page 41, my lord, SBI.
Yes, this amount has been paid, sir. I wanted to see this, yes. Page 40 and 41.
Page 41, this is the page.
That pay 25 lakh. Yes.
Please
That
read the
20
entire
lakh
thing.
adjusted towards.
That has been done already. Adjustment will be done by you, sir, not by him. No. Out of the entire gratuity amount, that amount will be adjusted, the remaining amount paid to him, that has been done by your authority. Sir, one question. Who is opposing, the lawyer or the client? I am having this doubt within actually. The documents are staring at our face.
I was instructed that there has been breaches, other breaches are also there, madam. Well, because this is for final disposal, my lord, and
This is for final disposal and I really do not find
For a long time.
anything further in this. Since it's a memorandum of understanding executed by your client. And the documents further reveal that these conditions have been dealt with completely. Come back on Friday.
Tomorrow, Friday, I've got some other engagement. Lady, please tomorrow. At 10:30. Everything is there. You just give, you'll get instruction from the client. Nothing more than that. 10:30 at the top of the list.
Yes.
For order, tomorrow. Excuse me.
Third learned counsels for the parties.
For order.
Let the matter appear under the same heading on Calcutta, 19th.
Oblige yourself. At 10:30.
It will appear under the same heading.
At the top of the list.
All the lists. Passed over.
46 are on the state.
Passed over. No, further, let's make it,
47.
for these are contested applications, so I'll send it to the next circuit. 46. None appears for the petitioner, no accommodation is sought, learned counsel for the state is present. The matter be placed before the next available circuit bench. Whole day matters cannot be passed over.
47.
47, I have for the petitioner. So I have come before your lordship challenging an order of issue of proclamation against the petitioner. You last occasion, your lordship kindly come, the order dated 9/7/2024.
You have served?
Yes, your lord, state is the only party.
You're a CD will not be required for an order of proclamation.
Order dated 9/7/24.
5th August 24 is the order that you're challenging.
Yes, Lord, come, can you come? 9/7/24.
Yes.
But can you come, Lord? Considering, this is third paragraph, considering all those aspects, the prayer submitted by IO is hereby allowed for the sake of investigation, issue warrant of arrest against the accused person noted above. This is the petition before the lordship. On to 26/9/2024 is the here for warrant of arrest. But 26, kindly note the date 26/9/2024. And the Lord, if the in the meantime, the proclamation has been issued, my lord, 25/8/2024, before the date of execution of one date. Section 82 is very clear, my lord. Unless the
Section 82 is very clear. Where is the, when was the returnable date for the warrant?
it's the 26/9.
26/9.
Yes.
Yes.
The before that one proclamation has been. Oh, what a shit of it.
Again on 23rd August, another warrant was issued.
Twenty-third,
23rd August order. The same persons, Reena and Kalavati.
All the orders, the orders checking your favor,
This is a point of law. No question of being a favorable or a unfavorable order. No, no. Warrant of arrest was issued on 9th July, fixing 26th September for ER. Where is the non-execution report before issuance of WPA? Basic question. It will be in the order also. Orders are annexed. 26. Yes, please complete it. You cannot issue a WPA before the returnable date. Returnable date. There should be an NER before a WPA upon NER. How court cannot be satisfied in the air. There should be some basis for satisfaction. Where is that? And then after WPA was issued, again a warrant of arrest has been issued. How? Please see the 26th August order. You have served copies, right?
Yes, your lord. It's half copy.
26/9 for year. Yes. Before that, on 5th August, a prayer was made for WP and it was issued. And that to WP and A issued simultaneously.
Maybe for the different actors.
No, my lord, this is the two.
There is no maybe, sir. Unfortunately. The returnable date was in September, 26th September. And there was no NER. Fifth of August, WPA, 9th of, after 4 days.
Tina Goal and Kalavati Goal are as well. Only for this lady, one of,
These ladies are the petitioners. Warrant of arrest was issued, 26/9 was the returnable date. 5th August, much prior to that, no NER. WPA is issued, that to P and A together, which is not permissible, which is illegal. A proclamation and an attachment cannot be issued simultaneously. 82 and 83. There has to be a 30 days notice. Thirdly, absolutely faulty. 5th August, it is issued. 9th August is the returnable date. Where is the 30 days gap? Let us not spend further time on this. Affidavit of service, third learned counsels for the parties. The petitioners have assailed the order passed by the learned Chief Judicial Magistrate, Jalpaiguri, on 5th August 2024 in GR case number 2554 of 2024, directing issuance of warrant of proclamation and attachment against them. Paragraph. Paragraph. It appears that on prayer of the investigating officer of the case, warrant of arrest was issued against the petitioners by the learned magistrate on 9th July 2024, fixing 26th September 2024 for execution return. Stop. On 5th August 2024, the investigating officer prayed for issuance of warrant of proclamation and attachment against the petitioners, which was allowed, fixing 9th August 2024 for execution return. Stop. No non-execution report of the warrant of arrest was submitted by the investigating officer prior to seeking issuance of warrant of proclamation and attachment. Stop. Warrant of proclamation and attachment was issued simultaneously by the learned magistrate, which is unknown to law. The returnable date for execution return was fixed on 9th August 2024, that is, prior to expiry of the statutory period of time. Paragraph. In view of the above, this court is inclined to hold that the order dated 5th October 2024, directing issuance of warrant of proclamation and arrest, proclamation and attachment simultaneously, is beholds the provision laid down under section 82/83 of the Code of Criminal Procedure and is required to be set aside. Paragraph. The divisional application being CRR 340 of 2024 is allowed. Paragraph. The order impugned dated 5th of August 2024 passed by the learned Chief Judicial Magistrate, Jalpaiguri in GR case number 2554 of 2024 is set aside / quashed. Do you intend to surrender?
Yes, Lord. I would apply my anti-federal before the government.
Urgent certificate. He has come up against that particular order.
Yes, sir.
Do it in accordance with law. The code goes somewhere, the orders go somewhere else.
My lord, permit me to, on behalf of the others, two courts are already been over because of this,
Not to attend resolution is there, my lord.
Where is the resolution?
The resolution actually, there are not.
But we have in our group, Lord, court number
Is that
3.
sufficient? Where is
no,
the
my lord.
official intimation to the court?
No.
Take it.
Lord, the division
Yes.
bench as well as the court number 3 Justice Bhattacharya has also read.
Maybe they finished their work. I have not. We have
No, but
not been
since
given
the
the
court has
resolution.
risen,
Please
it
show
was-
me the resolution. Has to be officially communicated, sir.
Lordship.
This is a court.
But the difficulty is the bar.
Actually, we are follow the same resolution.
Of
Principal.
principal bench says not to pass any order in absence of any of the parties. It is not a not to attend out order. I have seen the resolution of the principal bench. Doesn't stop the court from working.
Actually, two courts are already been.
I'm sorry, maybe they have finished their work. I have not. I have lot of work to do still. There are lots of passed over matters. I have lot of work. If you can show me a resolution, I'll deal with it. I'll honor it. I honor your resolutions, but then there should be some resolution. Where is it? Next.
I am appealing for the petition.
This is very embarrassing for the court when you say that this is not done. If there's a resolution, there should be an official communication. If that's not there, these submissions are unwarranted. Yes, who's appearing?
I am for the petition, Lordship. Lordship, I have come before your Lordship for setting aside of an order of whereby the Naraji application was allowed and re-investigation order was passed, Lordship. The
Re-investigate, where is the order?
Yes, Lordship. In this case, FIR was lodged under section 376, 417, 323, 379, 427, 506, 34. And after the FIR, the petitioner got married with the opposite party number 2. And thereafter, the police filed FIR. Against that order, the opposite party number 2 filed a Naraji application, and the order was passed, Lordship. Last page of certified copy. This is the order. The order date is
6th August.
6th August, Lordship. Last page, Lordship. Certified copy, last page.
It says further investigation in the earlier paragraph, but later on again it says investigation.
Yes, Lordship. But the operating portion says re-investigation.
But the body says further investigation.
And Lordship, the opposite party number 2, she got married with the petitioner. And after marriage, how this 376 case run?
Anyone appearing for the second opposite party? You are appearing? Yes.
There is admittedly there is a existing relationship, romantic relationship between the couple. Then there was a denial of formal marriage by between the spouse, Therefore, FIR was registered. Okay, FIR, there is a FIR is not maintainable, there is a pre-existing romantic relationship that culminated into frustration of true marriage. This is one thing. Second is this, immediately thereafter, the 2 days thereafter, Lordship, the accused person agreed to got married. And accordingly, both the couple approached to a registered.
Not only the accused person, the complainant has also agreed must be.
Both the person.
Page 21 is the marriage certificate.
And forbid. Within 2 days, after 2 days after registration of the marriage, after then, both the couple approached to the marriage register, issued the registration notice. That notice was issued immediately 2 days thereafter. After exhausting 30 days, the marriage was formally registered. Then the accused promised me that there was a social marriage and they will continue as a husband and wife thereafter. On that premise, an agreement was executed before the notary public. That was communicated to the court basis court. On the basis of this particular execution of agreement, the learned court bureau was pleased to pay for an interim number one. Number two, the same copy was communicated to the investigation officer. The investigation officer thought it that since settlement has arrived at, so he filed a FIR. After getting the investigation bill, he somersaulted, and thereafter immediately dumped the complaint. Then there are no social marriage, no lead of many marital life, nothing that. Now she has been made vagabond. This is the precarious situation where when the FRT was filed, I was served with a notice from the Learned Court Bureau. I approached the Learned Court Bureau and filed an analogy petition. This is the whole sum of the case.
After the marriage, if there is any allegation, how can 376
No,
case run?
now
There was no social marriage, only the registered
Exactly.
marriage. There is some case.
exactly.
That is a different
Exactly.
thing, Lordship. And they are saying about the agreement. How can there be an agreement of marriage, Lordship? That agreement
Not
is
agreement of marriage, agreement to
He-
settle the allegation, the issue.
Now the post breach of promise is after 1st July 2024. Now section 69 of GNSA will apply according to my humble submission. Now my client, I'm told that they are going to assign the particular dispute agreement because the context or pretext under which the agreement was executed is no longer existed. So this is completely null and void. So I'm told that they are taking a necessary step against that particular agreement. Now on the basis of this development, the Naraji petition should be heard out, and since heard out, so further investigation can be carried out in that terms. So this is my humble submission. Section 69 is quite different from section earlier section 416 and 376 and 470. So there is the difference. Lordship kindly knows better than me. Now on this particular premise, this case cannot be cross partial. Otherwise, I would not.
No, I'm saying
He is
not
not
saying-
asking for quashing.
Certainly, but they are asking for a.
There is a one technical difficulty. The ordering part says re-investigation.
That can be.
That has to be further investigation.
So I have no objection.
And the order is not a reasoned order at all.
Yes,
All
let
that you
this
are
order
saying
be
it
set
needs
aside
to
and
be-
let it be.
Needs to be
be
recorded.
heard.
I'll send this for a further remand.
Good.
Let the court hear both of you and pass a reasoned order. It's just stated upon consideration of the submission at length, I am passing an order.
Certainly.
For a further investigation,
Certainly.
there should be a
Yes,
reasoned
what
order.
is calling for your lordship is absolutely fine.
I'll send it back for a reconsideration.
And let this order be set aside.
Okay,
Yes, has to be.
my submission can be recorded accordingly.
The petitioners. The first petitioner is the
Yes, husband,
husband.
husband.
And have you served the private opposite party?
Yes, Lordship. He is for the private.
Oh, you are the private opposite. And the state?
State I have also served, Lordship. What?
Not today. Why are you under the impression that there's a resolution alone? What is circulated? Please tell me. The principal bench resolution. Please read what is there.
No, we have talked to it.
Yes.
In case of,
Absence of-
not in the adverse.
In absence of any of the parties, yes. So motion matters can be taken up. Where both the parties are there, those matters can be taken up. Yes.
I
I'll make
think
it not to-
state is not a necessary.
Whatever is a party. You have implemented the state as a party. Not today. No. I will. State. Do you have a separate resolution of the bar? I was informed that there was a 330. No, nothing of that kind. Next.
49.
For the petitioner led by Mr. Ovi Khatak. He is on online. Show him the Mr.
Your Lordship, Mr. Ovi Khatak is not here. I will be assisting Your Lordship online. However, only one prayer, Your Lordship, if the matter can be placed on Friday, Your Lordship, because Mr. Khatak and both Mr. Saurabh Chatterjee will be appearing.
Friday. Learned counsel for the petitioners seeks accommodation. Let the matter appear under the same heading on 20th December.
Grateful.
It's a contested application. I have my doubts whether it can really be taken up.
We
We have very few days left.
Yes, Your Lordship.
Yes. So let it appear before the next circuit.
Your Lordship, the only issue is that we were enjoying. Your Lordship, am I audible?
Yes, you are.
The only issue is that we were enjoying a stay. These four are all matters which are tagged together. Because
Date.
Your Lordship, I'll assist Your Lordship.
49. Act again.
Lordship, I'm appearing for the private respondent. I'm led by Mr. Senior Advocate Mr. Amlesh Rai, Lordship. Kindly takes it up tomorrow, Lordship. Lordship,
The stay is till which date?
Your Lordship, I'm assisting Your Lordship. Your Lordship, perhaps, I apologize, Your Lordship, perhaps the matter, the stay has been exhausted, Your Lordship, perhaps. My Lord may takes it up on Friday.
Friday will be difficult to say. Contested application, 4 matters. This is we have lesser time this time, isn't it? Tuesday is the last working day. So I'll place it before the next circuit, which starts from 2nd January.
Lordship kindly takes it up on Friday, Lordship.
Not possible on Friday. There are 4 matters together. I cannot take up big lengthy matters. These are contested applications. I'll in fact put the contested applications out of list from the next day maybe. I cannot take them up.
For separate case.
Separate cities, yes. Learned counsel for the petitioners seeks accommodation. Paragraph, let the matter appear under the same heading for the next available circuit bench.
Your Lordship, if I may, Your Lordship, if I may say something.
Yes.
Actually, the last order of stay, Your Lordship, was granted on the first date of the hearing, which is on 11th September.
I've seen
However,
that has expired.
yes,
So
on the
we will
next
file a
day.
fresh application in that case. 2nd
Great.
January, the next circuit starts.
Great.
Next. Not running. 53? Yes.
Lord, I'm on behalf of the petitioner, my lord.
My Lord, I am led by Mr. APP.
Yes.
But I am on behalf of the defective complainant.
Well, the FIR was drawn under section 341, 326,
Case diary was called. Yes,
My
continue,
lord,
please.
my lord, amicable settlement they've come into amicable settlement, my lord. Now, continuing with this process, my lord, it is just the misuse of.
You are the private opposite party? So a settlement has been arrived?
Yes, my lord.
I'll request the state to record the statement of the de facto complainant. I want to have it on record. Come back on Friday with the statement.
Yes, my lord. Jor Banglo police station, no? Jor Banglo.
My lord, a short indulgence, my lord. My lord, we had an interim protection of no coercive action, my lord.
Till that adjourn date?
Yes, my lord. We have filed the extension
Then
within the.
I will come back on Friday. I'll dispose of the matter.
Yes.
I only want to record the statement of the de facto complainant.
Okay, my lord.
So that she doesn't prevaricate on the next occasion, right? Learned counsels for the parties submit that the dispute has been amicably settled between the parties and the de facto complainant / private opposite party does not intend to proceed with the matter any further. Paragraph, learned counsel for the state is requested to submit a report on the adjourned date in with regard to the mutual settlement arrived at between the parties. Stop. The report should contain the statement of the de facto complainant / private opposite party in this regard. Paragraph, let the matter appear under the heading to be mentioned in the morning.
My lord, de facto complainant and victim are two different people, my lord. So if my lord wants
Let
to.
it be both.
Okay.
That should contain the statements of the de facto complainant and the victim / private opposite parties in this regard. Let the matter appear under the heading to be mentioned on 20th December.
Grateful.
20. Compromise. Next. Oh, the interim order granted earlier is extended till the adjourned date. The interim order granted earlier is extended till the adjourned date. Next.
My lords, I am for the petitioner. My lords, this is a case of section 306 of IPC. My lords, prima facie, there is no evidence against both the petitioners herein. My lords, let me get into the facts of the case and then I will go to the law points.
Give me a minute, please. Have you served? There's a private opposite party also, right?
Yes, my lords. I've served, and my lords, last day I had given the affidavit of service. Although an order has not been recorded, but I had submitted.
Give me a minute. Served.
Grateful, my lords.
I'll make it not today since you have brought the resolution to my notice.
My lords, I am willing to do, the state is also there.
The private opposite party. It's
My
served but is not appearing. Tomorrow I'll be.
Tomorrow again, what I hear is there's
There's
some
a resolution.
my lords, and keeps it on Friday, fixes a. My lords, please fix the matter. My lords, I'm not enjoying any stay also in this case. Therefore, the final hearing is really important, my lords. It's a case prima facie, there's no evidence.
But only all 207 copies are there.
Yes, my lords.
Within this brief, my lord. Case diary is needed, my lord.
My lords, last day there was a direction. My lord, for me it's sufficient, but there was a direction to call for the case diary on the
Day after tomorrow.
My lord, they fix a time for it, otherwise.
Time will not be possible.
My lord, otherwise there's a
I
lot.
am able to exhaust the list, so don't worry.
Grateful, my lords.
Affidavit of service. None appears for the private opposite party despite service. Paragraph, let the matter appear under the same heading on 20th December.
Grateful, my lords.
Next.
My lord, 55, I am for the petition.
Yes.
Lordship is a non-compliance of the 197 CRPC. Matter is non-compliance of 197 CRPC.
Passed over matters will not be called further today because I find you are in difficulty.
Yes, madam.
Since I'm not agreeing to your proposal, no, let them all come back tomorrow. Passed over matters.
Passed over motion matter, not other side. First motion.
Come back tomorrow, come back. Since I'm not agreeing with your
Yes.
proposal.
Lordship is lordship.
Yes,
Lordship.
this is at the motion stage.
Motion. No, motion stage and copy has been served. Copy has been served.
Copy has been served.
Served. there.
The bone of contention is 197. The provisions of 197 whether followed or not. Lordship, what we have done is the IOS Lordship send the intimation to the post office for conducting 197. But the post office after the filing of the charge sheet and before the filing of the charge sheet, they have sent the intimation. The post office has not replied to their
Therefore,
requisition, Lordship. So that is our main problem.
The Lordship 197 has not been, therefore cognizance has been taken. So there is the admitted fact that the statutory provision has not been completed. Cognizance has been taken. That is been Lordship, the last page, my certified copy. Last page, order dated, order number 19, dated 1st March 2023. Get it, Lordship? Last page, certified copy.
Yes.
Now, Lordship, this is a public servant. Public servant, and Lordship kindly see the charge sheet. We go to charge sheet. Prior to that, go to charge sheet. Lordship kindly see the FR. This FR is page number 15, and in FR, if we will kindly see the bursary view over the year, I have not named in the FR. My name has not been FR. Now, how my name has come to the, that is been my page number 18. Page number 18, P3, Lordship. That is, Lordship, page number 18. That is forwarding report of another accused. Another accused. And in page number 19, 18 on last part, during investigation, page number 18,
Yes.
and except P3. During investigation, as per the source information, I arrested accused Bapi Sarkar. I am not Bapi Sarkar. Bapi Sarkar, such and such, Jalpaiguri district, Jalpaiguri, and taken into custody upon interrogation. He
There's some,
statement.
please, there's some conference going on behind. Let them finish. Yes, continue.
Taken into custody upon interrogation, he confessed his guilt and disclosed one Robi Das of Guwahati has been given the one car scanner since 1.5 months back. He purchased the same as rupees 5,000 without any valid document, with fully knowledge of the car scanner, stolen property, and handed over to Sunil Agarwal for sale in the out secretly. He has a good relation with the contract of the accused Sunil Agarwal, Robi Das since long. Hence, I see that has been Robi Das. Found
This
Robi
is
Das.
Vishwajyoti.
Yes, Vishwajyoti, Lordship. Now the charge sheet, page number, certified copy. Lordship kindly came to page number 4 out of 9. Our serial number 4, I have been designated as the accused. And the fact is, come on to page number 7. Third paragraph. During investigation, perusal of the FIR, it reveals that one Sunil Agarwal.
Page number?
Lordship, this is the FIR, charge sheet.
Yes.
Charge sheet, page number 7. That has been last, just beneath the number 7 out of page number 7 of 9.
Give me a minute, please.
This charge sheet, certified copy.
7 of 9, yes.
7.
Yes.
Now come to the page number 8, Lordship. During investigation, collected report from Assistant Director of RMC Lucknow region regarding the end of the disposal of particular speedboat such and such. During investigation, arrested accused Bapi Sarkar, but such and such. Upon interrogation, he confessed his involvement and the said one Vishwajyoti Nath, the RMS guard of Guwahati, had given him the car scanner, and after they received the same, sold to Anil Kumar Agarwal, Siliguri against 6,000. He also stated that since the January 2000, he gifted one Jio SIM card for Vishwajyoti Nath, having number such and such, issued in the name of Subroto Sarkar of Dokhin Bharatnagar, Siliguri, and presently Vishwajyoti Nath using the mobile phone number accused Bapi Sarkar has been forwarded to the learned court and then taken into police remand as per order. During remand period, he can be interrogated as 161. Now, Lordship, just come to the last part on 9/6/2022. Last part, same page.
196 received order from Circuit Bench Jalpaiguri. Theorem number where accused Vishwajyoti Nath granted anticipatory bail such and such upon furnishing bond of at the amount with a true surety. During interrogation, Saint Prayer Superintendent of Railway Mail Service, Guwahati Division for sanction of section 197 CRPC against accused Vishwajyoti Nath. He was as a public servant at the time of the crime, but sanction has not been received. I submitted prayer of the Chief Master Goa Assam, Guwahati Assam for according to sanction 197 against accused Vishwajyoti Nath. So there is no sanction. And there is no public servant, that is there is a public service public servant, and this section 197 has not been complied with, and therefore saying that a clear section on 197 very much clear. Lordship, kindly see the 197. Prosecution of judge and public servant. Can I read?
Yes, yes.
When any person who is or a judge or magistrate or a public servant not removed from his service save and all the with the sanction of the government is accused of any offence alleged to have been committed by him while acting or purporting to act as a discharge of his official duty, no court shall take cognizance of offence except the previous sanction. In central government, that is in state government, that's it. That's I have some ruling in this way.
Not necessary. The statute is very clear.
But may I?
Yes.
But I am holding the case study, but after initiations, the case handed over to the CID, and CID took the investigation, and thereafter charge sheet has been submitted with the clause of the supplementary charge sheet. But all the 161 statement is highly corroborated with the prosecution case. And my lord,
We are on a technical issue. We are not on the
yes,
basis
my
at
lord.
all.
Moreover, my lord, sanction is a issue, my lord. We at a part of the investigation agency, my lord, after before charge sheet and after charge sheet also communicated to the, my lord, I am just, this is the.
That is not important. What is
Yes,
important
yes,
is
madam.
the
I'm
sanction.
just, yes.
And cognizance could not have been taken unless there was a sanction.
My lord, actually, the postal authority, they are not responding. So on our part, my lord, they can assist in this pretext, my lord.
No, this is not a pretext. This is the requirement of law.
My lord, but we.
So you have
we
to
are,
take necessary steps, ask for taking steps against the authority.
my lord,
Whatever it is between you and the authority inter se.
my
The
lord,
petitioner will not suffer for that.
my lord, my
He
lord,
is the accused. There has to be a 127 sanction.
my lord.
So cognizance is.
But my lord, prima facie is clear, my lord. But on that part, my lord, this is not hand of the prosecution, my lord.
Unless
Prosecution,
197 sanction is there,
my lord.
cognizance cannot be taken. There
Charge
is
sheet
no
also.
exception to it. So
Even
charge
charge
sheet
sheet is
would not have been
with
filed
sub-
without the sanction.
Without sanction.
Because once charge sheet is filed, cognizance is
Then
taken nowadays automatically.
My lord.
The court doesn't even look into it. I am sorry to say this, but magistrates don't even look. It's a very stereotype order.
Stereotype.
Charge sheet submitted, cognizance taken.
My lord.
Sometimes we find typed
Typed
copies.
It is
where
also
only
typed on
the blanks are filled up.
blanks. There is a space blank.
Though the law does not endorse such cognizance, it is normally taken. So the cognizance is bad in law.
But on the 409, purpose of 409, cognizant
that,
sanction is must, my lord. So, my lord, and other section, my lord,
That will be the charge sheet already been.
other section, my lord, there is no.
No, anything. Any crime.
Other
I can say,
section
no,
wise-
only not 409, 420 also will, because of.
470, 379, 411, 414, these are all connected to
connected.
this public activity.
My lord.
So could not have been.
But we have, on our part,
That is interested, the petitioner will not suffer. You have to take necessary steps in that case. You have to move the higher authority, whatever steps is there. Under the law, you can take that.
My lord.
charge sheet could not have been filed without the sanction.
Sanction.
You are aware of that.
Pattern of judgment there is. We read
Very much. Communications were given, my lord, in spite of that, they never, my lord, gave any answer to our call.
pattern of judgment there is.
And the statutory period was getting over, so you submitted the charge.
Submits.
I was submitted the charge, but that's not the law. I have to set aside this cognizance.
And charge sheet also.
He is the only accused.
No. That rest are private person.
He is the only.
Rest are private.
Rest are
Mr.
person,
Kapoor.
yes. I am the government.
So cognizance against him is bad in law, has
Bad
to be
in-
set aside.
And a charge sheet also. The charge sheet because of the, prior to charge sheet, he needs to.
When
be
the
sanctioned.
cognizance is set aside, that indicates that there is no charge sheet against him. Charge sheet, cognizance has to be taken, right?
So charge sheet.
Then only the charge sheet comes into operation.
Then
If the court doesn't take cognizance, there is no charge. The
Charge-
charge sheet doesn't come into operation.
Lordship.
So I'll set aside the order taking cognizance
Cognizance.
in respect of this person.
Charge sheet, in
Yes.
respect of charge.
And there is not much to discuss on this. The law is very clear. The petitioner, who is admittedly a public employee, seeks quashing of charge sheet number 109 of 2023 dated 24th February 2023. Corresponding to special case number 32 of 2021, pending before the learned additional sessions judge, second court, within bracket, special court under section 409 of the Indian Penal Code, bracket closed, Jalpaiguri. Jalpaiguri, primarily on the ground that sanction under section 197 of the Code of Criminal Procedure was not obtained prior to submission of charge sheet or taking cognizance there. Paragraph. It is not in dispute that charge sheet was submitted against the petitioner and three others under section 379, 409, 411, 414, 120 capital B of the Indian Penal Code, and cognizance of the charge sheet was taken by the learned additional sessions judge, second court, Jalpaiguri. Reday order dated 1st March 2023. In taking cognizance thereof, the learned additional sessions judge did not take into consideration that there was no sanction under section 197 of the Code of Criminal Procedure prior to submission of charge sheet against the petitioner, who is a public servant. Paragraph. In view of the fact that cognizance of the charge sheet could not have been taken by the learned additional sessions judge, without the charge sheet having been submitted, upon receipt of sanction under section 197 of the Code of Criminal Procedure, cognizance taken in respect of the petitioner is bad in law and is liable to be quashed. Paragraph. The revisional application being CRR such and such is allowed. Paragraph. The order dated 1st March 2023. Passed by the learned additional sessions judge, comma, second court within brackets, special court under section 409 of the Indian Penal Code, bracket closed, comma, Jalpaiguri, in connection with special case number 32 of 2021, insofar as the petitioner is concerned, is quashed slash set aside. Paragraph, however, the investigating authority is at liberty to submit charge sheet against the petitioner after compliance of section 197 of the Code of Criminal Procedure.
Grateful, Lordship.
Urgent certified website.
Grateful.
A curable defect.
Grateful.
Next.
Lordship, item 56, I am praying for not today.
Not today. Not today.
Lordship, praying for not today. My senior is in code 3, praying for not today.
Not today.
Madam, for the applicant.
At the motion stage.
My lord, this was a disposed of revisional application, my lord. Subsequently, my lord, the learned court below did not abide by the directions that were given in the while disposal. My lord takes. Page number 49.
There was, liberty was granted to file an application under section 36. Was it filed?
My lord,
That's the earlier order, isn't it? 11th November order.
11 November, my lord. The direction was so that my lord kindly takes my CAN application. 11th November.
Yes. What is the application about?
My lord,
Yeah.
the 36, it was corrected in the next order, my lord. It was to be 12. 7/10 and 25 of Guardians and Wards Act, my lord, instead of Special Marriage Act. That was corrected to by the subsequent order at page 10. My lord, I had sought for a visitation right, my lord, during the pendency. I am a father. The wife has abandoned me since the birth of my daughter. I have not been able to see her. And court, considering my position, had directed in 15 days to file an opposition and within 30 days thereafter to place for hearing. My lord, kindly takes the order after which the record was put up. That is at page 11, my lord. Even though it was a contested disposal, the learned court, without seeing that, has fixed the date to date, in frustrating the entire order passed by the Honorable Court, my lord. My lord, now today my innocuous prayer here, my lord, I need today, Christmas and New Year is coming. Schedule visiting my daughter, my lord, at a public place anywhere convenient, my lord. That is all I pray, my lord, to see
You
my
were the
daughter.
petitioner in the earlier application also.
Yes, my lord, I was the petitioner.
So the section 36 was filed by
No, my
the.
lord, 36 is mistakenly written in that order, my lord. It was section 7 and
Yes, 7, 10, 25. So
25.
this was supposed to be filed by the,
it is filed, my lord. That is pending.
by the opposite party, right?
No, my lord, by the petitioner. That is filed, my lord. That is under consideration before the learned court below.
So you're asking for expeditious disposal of that application?
My lord, even that was allowed by this is the revisional application. But my lord, the learned court below has not given effect to that order passed by the Honorable High
No,
Court.
revisional, no, this directs the trial court to dispose of the pending applications for custody and guardianship.
Yes, my lord. Within
1
50.
month
Yes.
thereafter.
Yes, my lord.
So when was this application filed?
My lord, this application was pending before the court. For it was not being heard. That is why I had
No, the
approached.
direction was to dispose of the application within 1 month from the
From
date
the-
of filing of that.
No, my lord. It was pending. From the date the opposite party was to file 15 days, objection was to be filed by the opposite party. Thereafter, within 30 days, hearing was to take place.
Yes, I need those dates. When
My
the
lord-
objection was filed and.
My
the
lord, it's not
application
been
was
filed. the liberty was given by the honorable court in this order, my lord,
Why
on
don't you
11/11/2000.
Why don't you serve and come back?
I've served, my lord. I have the affidavit also. My lord, kindly
Was
take.
anyone appearing for the opposition?
Yes, my lord.
Earlier?
Yes, my lord. Kindly takes, my lord, page 8
Give me a minute.
of my CAN application.
Give me a minute. Where is the service, the track report? Some protected activity.
Okay. I am back.
Activity.
The practice. My lord, it has been served, my lord. I'll
Not
just
today.
attach.
I'll just make it not today. Come back tomorrow.
My lord, if it could just.
Not today only. Not today. 60. You're appearing petitioner?
My lord, affidavit.
A complaint case?
No, this is a revisional application arises out of a decree passed in section 6 of the specific relief act.
There are 5 opposite parties. You have served
Yes,
all of them.
all out.
So I'll just make it not today. In case they appear tomorrow.
Then keep it on Monday, my lord, from Friday, Tuesday.
Tuesday, not possible. That's the last working day.
Because
Not the
tomorrow and the day after tomorrow, we have an election in our,
Day after tomorrow, there's no election. It's only tomorrow.
tomorrow counting is day after.
You're involved in the counting.
Yes,
also.
I am in the election commission itself.
Oh, so I cannot stop you. You'll come back on Monday.
Monday.
Affidavit of service, none appears for the opposite parties despite service. Paragraph, let the matter appear under the same heading on 23rd December 2024. Next.
61, my lord, I am for the petitioner. My lord, this is a civil revisional application, my lord, arises out of confiscation proceedings initiated by the divisional forest officer. My lord, challenging that order, my lord, we had preferred an application under section 59D of the Forest Act before the learned district judge. My lord, that statutory appeal was turned down, my lord. Challenging that appeal as well as the confiscation order, my lord, we are before your lordship. Now, my lord, I have no, my lord, this is a motion stage. So initially, my lord, I'll be pressing for interim relief and then, my lord, I'll serve.
Why do you need interim release, sir?
My lord, because, my lord, I'll just impress your lordship, my lord, with 3 points. First is, my lord, they say that my tractor was lifting sand from a forest riverbed area. My lord, I have submitted a valid movement pass issued by the BDO. My lord, that movement pass was verified by the officer, by the authorized officer, while the confiscation proceedings were going on. And my lord, he has given a report that yes, this pass was issued from my office. My lord, only on I'll just place that part to your lordship. My lord, may come to page number 70. The confiscation order.
1717.
17, my lord. My lord, the last paragraph. May I read, my lord? Annexure P1, last word. Hearing notices were sent to the person having current possession and general power of attorney of the vehicle, Shri Mohanlal Tamang.
Page 17 doesn't say, so this is the amended written statement.
Lord, 17, Annexure P1, Lord.
This is P2.
Pagination ভুল করেছেন নাকি?
Annexure P1, page 11.
Huh?
That you're referring to the plaint.
No, no, my lord. The proceeding, the order of the authorized officer. Lord,
So P1 is the plaint.
Lord, may I have a look, Lord, for a moment, Lord? Perhaps there is some problem in the pagination. My lord, this is not this matter, my lord.
61. 210 of
My
2024.
lord, there is some problem. This petition is not mine. This petition is not mine, my lord.
But this is 210 of 24.
This is CO 15 of 2023, my lord.
Fantastic. Not today. I'll just
My
find out what some.
Lord, I'm grateful. আমারটা 210
Next. Yes.
Proceeding number 1 filed application under section 24. Her claim was rejected by the landlord. She has children also. The landlord court has.
You need to serve at them.
Yes, madam.
Mute forum. The petitioner is aggrieved by the order passed by the learned additional district judge, fast track court, Siliguri on 20th June 2024 in Miss Case 9 of 2023, turning down her prayer for maintenance. Paragraph, the petitioner is directed to serve copy of the application along with annexure thereto upon the opposite party and file affidavit of service on the urgent date. Paragraph, next circuit. The matter be placed before the next available circuit bench. Paragraph. Next.
Lordship, I am appearing for the item petitioner in item number 63.
63. Not today.
My lord, appearing virtually.
Sir, I am appearing for the petitioner in the item number 63. Lordship.
Yes.
This is a restoration application. And so my criminal appeal was dismissed for non-prosecution. Lordship.
Please
On
serve.
16th.
Have you served?
Lordship, no.
The state was present when it was dismissed.
Lordship.
So please serve the opposite parties and come back.
Lordship, kindly fix the matter on Monday. Then I will have them.
The petitioner is directed to, the appellant is directed to serve copy of the application along with annexure thereto upon the respondents and file affidavit of service on the urgent date. Paragraph, let the matter appear under the same heading on 23rd December 2020.
Grateful. Lordship.
Next.
But I am for the one opposite party. But I am for the opposite. Sorry, once upon a time, your loss is hard this matter also.
if you call your office, going to remember. Thereafter, my learned friend wanted to sign one
You are the
judgment,
petitioner.
but
Let me
till
hear the
today,
petitioner first.
that judgment has not been supplied to me by my learned friend. The other day, my lord, when your lordship heard this matter, he cited some judgment. And according to your lordship, my lord, your lordship also asked him, but please hand over the copy or give the citation to me so that I can go through it. Till today, he has not yet.
Several
Anyway,
judges
Mana,
got
he's
copy.
No copy, served, no, not my lord. No copy served upon me.
nothing. I cannot go through the judgment also.
These are
But
voluminous.
judge,
Yes.
the decision, he wanted to cite some decision.
No,
All of them are not reported. All of them are not reported judgments. You need to give, these are civil revisional application, civil appeal, these are not reported.
lordship.
So you have to give copies.
No, I do not know. And this
Next
matter was heard by Manager Ajay Mukherjee also. And that was the heart, that was the pattern. The pattern was also released.
This is a
He did not
contested
do it.
application, next circuit. I'll not have further time.
I know, Manager, that is our today is a principal bench. Your law system, all the courts are not done. In spite of that, I appeared virtually. Only for your law, this matter.
No, but the resolution is not for not attending.
No, not attending. But your losses knows us also. The body is here. Body came to this court also.
Naturally,
that,
yes, naturally.
that is why I'm like, yes. But I'm requesting my management of my hand over the copy of that citation so that I'll not be prepared.
Learned counsels for the opposite parties submits. Copies of. Paragraph. The petitioner. Such copies. Learned counsel for the opposite party. You are.
Yes, I am junior.
Yes, my advocate.
Nonsense. By 2 days.
2 days no, it's Monday, because 2 days I will be engaged there.
By 23rd December 2020.
But I know my landlord is so busy. I get to it.
Election is going on.
Oh, election. Oh, yes. I know this is election. I get to it.
Beautiful.
Not today.
165 will kindly fix.
You
on
slept
Monday.
off. I'm calling them. Not today.
On Monday, my lord, if you look.
Matters
Sir,
can.
I understand, my lord. My learned brother just instructed me, my lord, on Monday, but kindly, my lord.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on Monday. I cannot take up, it will not appear. Contested applications will not appear in the list on Monday.
My lord, I know.
Just not today করেছিলেন।
Yes, my lord. That will also.
সোমবার থেকে contested applications রাখবেন না list.
My lord. Only not today will be here.
Next. Not today. Order লাগবে না। খালি not today.
Your lordship, kindly move it to the next circuit.
Next circuit. On prayer of the petitioner, the matter be placed before the next available circuit.
66, 67 is together.
That's together. Analogous, yes. Next. 68.
68, ma'am, not today.
69.
68 is not today.
Next circuit.
Contested
application.
Mr. Hindal Saha, he is in court,
Not
court
today.
number 3, not today.
Not today.
Yeah, my lord, needs to appear on behalf of the respondent parties, my lord.
My lord, I'm appear on behalf of the appellant in this matter.
Yes.
My lord, we will file the affidavit in opposition as the honorable court has directed us to file the affidavit in opposition. So, my lord, the draft copy is already prepared, but my difficulty is that, my lord, the key documents, the sum of the key documents are lying before the lower court. So, for that reason, my lord.
The section 5 application.
Yes, my lord.
Yes, my lord.
Very well. Learned counsel for the respondent seeks extension of time to use the affidavit in opposition as sought Paragraph affidavit in opposition be filed within 2 weeks.
My lord, kindly we fix this matter in the month of February, my lord, because it is very difficult for us to to collect the certified copy. We have applied for certified copies. We have yet not received the copies. And it will take some time, my lord. So kindly fix this matter in the month of February.
Within 4 weeks from date. Affidavit in reply, comma, if any comma be filed within 2 weeks thereafter. Let the matter go out of list for the time being. Get out of list for it. Next.
My lord, I am for the appellant claimant, my lord. There is a delay of 66 days, my lord.
Please serve and come back.
My lord, on last occasion, that is on 27/9/2024, there was an order to place some document, the certified, last page of the certified copy, which will enable the court to get the details when we applied for the certified copy. And we
Section 5 application is there. Have you served?
No, my lord, not.
You need to first serve the other side. Cannot be heard in absence of the other side.
My lord.
The petitioner appellant. The appellant is directed to serve copy of the application being Can 1 of 2024 upon the respondents and file affidavit of service on the adjourned date. Next,
Kindly fix it on Monday, we will file, we will
let the
propose-
matter appear under the same heading on 23rd December 2024.
Grateful, my lord.
Next. There's deficit stamp fee. So you have to file an application. But this is with regard to the statutory deposit. The certified copy is bereft of list of dates. Certified copy has been sent down to the trial court for necessary correction. So it has not come back. এটা ট্রায়াল কোর্টে ফেরত পাঠানোর কথা ছিল, ফেরত যায়নি তো এখনো দেখছি এখানেই পড়ে আছে। দেখুন স্ট্যাম্প রিপোর্টারের এটা দেখুন, স্ট্যাম্প রিপোর্টারের এন্ডোর্সমেন্টটা দেখুন। পাঠান। Let it be sent down. And no order need be passed. ওটা দেখিয়ে পাঠাবেন ডিপার্টমেন্টকে। The next one is also the same. The no order need be passed. 72 is not your matter, not to do. I have said I'll not take a passover matter, so come back tomorrow. I cannot pick and choose. You must understand. I cannot discriminate.